Good afternoon, ladies and gentlemen. Welcome to Burn the Corporate Fiction. Well, seems like it's crisis roulette. Pretty much, what are they going to land on? Are they going to do it all? We've got the impending quote-unquote alien invasion, and no, not the one from the southern border. They're actually really trying to sell this alien thing, and it's pretty funny. Also, they're cutting off people's EBT in Section 8, which personally, that shouldn't even exist in this republic. I'm going to explain why here throughout this stream. But that is a signal of an impending economic collapse with gold and silver at all-time highs, right? Which had been artificially suppressed, believe it or not, because, well, what is a dollar? United States debts are payable in gold, but the dollar is what the United States currency is measured in. And what is a dollar? A dollar is a measurement. It's an ounce of silver. So they've been artificially suppressed. Now they're removing that artificial suppression, and the price is blossoming, right? And that's because they're getting ready to pull the rug out from the economy, the worldwide economy, actually, because remember, the dollar is the global reserve currency. It's also not even a dollar. It's just a debt note, which we're also going to get into today. So with that being said, I'm going to show you how we fight back. So yes, I'm going to show you a problem, but I'm also going to show you how we fight back. The Juris Society and I, right, the other night came across something in Congressional Record that was quite significant. And so I've shown you guys many times that the 14th Amendment is invalid, right? And that it is unconstitutional. But buried in that section of Congressional Record where they were actually having this discussion is a court case. And it raised a very interesting point about the 14th Amendment in the first place, that its validity has never been upheld by the Supreme Court. So that's huge, right? Why is that huge? Because what I teach all the time on this channel to everybody is always challenge jurisdiction. If you end up in their equity court and you're trying to argue with them, it's over with. You need to challenge immediately at arraignment jurisdiction and point out why these administrative regulations do not apply to you. So I'm not going to go into the deep history of feudalism like I have been and stuff. We're going to start right with the United States. And I have some documents, and we're going to really explore the nature of the 14th Amendment, how it's voluntary, and also just not even valid. So despite being voluntary, it's not even valid. And their entire system is built on this 14th Amendment because the people created the states, okay, and stood above them. It's enshrined in court and case law, Chisholm v. Georgia. I'll show you if you've never seen it. And the states created the federal corporation, or the feudal trust, right, which became a federal corporation in DC, became a municipal corporation with the Organic Act of 1871. And then the United States Corporation created its own creature called the 14th Amendment citizen, which is actually an office of trust. I'm going to show you. It's easy just to look at the U.S. citizenship as an office of trustee. That's exactly what it is. It's what it's always been. It was designed for the newly freed slaves. I believe it was sold. I was actually just thinking about this last night. I believe it had to have been sold, or at least the way they came up, because everybody knew what it was back then. That's why 3/4 of the states rejected, or not 3/4, but almost half of the states rejected it when it needed a 3/4 majority to be ratified. They did some really dirty stuff that's also enshrined in case law and Congressional Record. And the validity of it has never been held up. But this, it's a combination of this 14th Amendment trusteeship with the Buck Act, okay, and Title 18, and the Trading with the Enemy Act. So it's a combination of the 14th Amendment, the Emergency Banking Relief Act, the Social Security Act, the Trust Indenture Act, the Buck Act, right, and the Trading with the Enemy Act as amended in the Emergency Banking Relief Act 1933 to include everyone engaging in exchange of bills of credit within federal territory. So the 14th Amendment is what has to be attacked, and I'm going to show you how to successfully just destroy it by the end of the stream, because it's an awful instrument of enslavement. What it did, it purported to give the newly freed slaves civil rights, which are actually just privileges. But what it actually did is it standardized slavery throughout the entire republic and then eventually the world once the dollar became the global reserve currency. So we're going to get into that. But let me say hi to those of you that are in the chat. We've got, let me go to the top here. We got Stephen Nichols on the Rumble side. Good to see you. I appreciate the compliment. We got Mark, or also known as Theo Shen. We have Living American. Good to see you as well. Dis123. Good to see you. And we got Pat, as always. Good to see you, man. Secret Asian Man, 007. That's awesome. Awesome name. I haven't seen you in a little while. Good to see you back. Brian Roy, Monty. Good to see you guys. Mojo, Jacob, fellow jurists as well, along with Theo, Living American, and wow, had a brain fart. Theo, Living American, and yeah, Dis. Thank you. Sorry, Dis123. Anyways, let's get into this stuff, shall we? All right. Very first thing is this. This digital system that they're trying to set up hinges entirely on the 14th Amendment. Why? Because the administrative state that has been created, that they're trying to make digital and permanent with the digital ID, this national trust that they're merging into a world trust under Unum Sanctum, which is a counterfeit trust. It's also, I was listening to The Painter, right? And I'm not going to say I'm a fan of everything about him, but he knew what he was talking about when he was giving speeches. And he said that communism is the creation of the fourth estate, and it is. And I thought that was very insightful and demonstrated his knowledge of the law. I did not realize he was so, but I guess it would stand to reason, right? And so these central banks, in order for communism to be established, there has to be a central bank. Karl Marx himself said this, okay? This world trust that they're creating is world communism. They're trying to make it a technocratic communism. They're trying to bring to life this world trust, this counterfeit trust, and the central bank is necessary, okay? Why? Because the governments, which are actually just crown corporations, crown companies, they always have been, the governments they need to take everyone under their umbrella in order to collateralize the citizenry and appropriate money from the third party, a central bank, which just by operation of law, but it's called the law of mortgage, places everyone's property in trust and reduces them to mere trustees of their own estate under administrative regulations. That's why, they can tell you how to use your property. You have to ask for permission to make additions to your home. You have to ask for permission to use your car. You have to ask for permission to hunt. You have to register everything. This is why, because it's all held in trust as collateral for the public debt. And it's very important to understand this. That's why communism needs a central bank, because it is that collateralization between the corporation, municipal corporation pretending to be your government, and the central banking cartel that causes this, what's called the administrative state. And I'm going to show you how to attack and destroy that today. But first, you have to understand what we were originally. Now, if you're not in the United States and you're listening to this, I can tell you, all countries started like this, okay? All countries started at common law. They started under common law because that's the original jurisdiction. It's the one not written by man. It's written about. Blackstone admits it. The Heart of Blackstone admits it. A Treatise on the Law of American Administration by J.G. Warner admits it. All jurists knew this about 150, 200 years ago. It's a fact. All right. Man does not create law. So at the revolution, we didn't create a new law. We just continued using the original law. What changed was we went from being a subject to the crown to being sovereigns. And now people have a mental block. Okay, people really struggle with this because they cannot imagine not having someone telling them what to do. Even if you know it's wrong, you've just been so conditioned to accept this throughout your life that you cannot imagine the government being beneath the people. But this is, in fact, the case at the beginning of this republic, and I can prove it. We're going to go to Chisholm v. Georgia, which actually, like everything that they do, is a double-edged sword. So let's see here. Share screen, window. All right. So Chisholm v. Georgia, right over here. It'll tell you At the revolution, the sovereignty devolved on the people, and they are truly the sovereigns of this country, but they are sovereigns without subjects, and have none to govern but themselves. The citizens of America are equal as fellow citizens and joint tenants in the sovereignty. Okay, so lawyers try to make the argument, well, that's as a political body as a whole. Well, no, because Chisholm v. Georgia further explains that from the differences existing between feudal sovereignties, which is where all the property comes under the administration of the governing authority, including the people and the labor, and then because all the people have been reduced to property, the centralized governing authority, whether it be a crown or whatever, can now tell the people what to do, even with their own bodies, all of their properties regulated. That's what feudalism is. Okay. It's a military style of law, but it really has very little to do with that. It's actually about absolute control, which is why all the monarchs of Europe adopted it. But anyways, from the differences existing between feudal sovereignties and governments founded on compacts, that's our government. Well, our original republic, our state governments. The federal government's not supposed to have anything to do with you at all, and that's what I'm getting into. But the compact was made at common law. And so when it says law in the federal and state constitutions, when it says law, it's talking about the common law. The people had absolute property rights. I'll show you that in a second as well. But anyways, from the differences existing between feudal sovereignties and governments founded on compacts, it necessarily follows that their respective prerogatives must differ. Sovereignty is the right to govern a nation, or state sovereign is the person or persons in whom that resides. In Europe, the sovereignty is generally ascribed to the prince. Here, it rests with the people. There, the sovereign actually administers. There's that administrative law. It's feudalism. Trust. It's a national trust. That's what feudalism is. Actually administers the government. Here, never in a single instance. Our governors are agents of the people and at most stand in the same relation to their sovereign, us, in which the regents in Europe stand to their sovereigns, meaning the government is your subject, man. Understand that. They can't tell you what to do with your property at all. They're not supposed to tax your labor or your property because you're supposed to have a lodial title. I'll show you that in a second. But anyway, it says that their princes have personal powers, dignities, and preeminences. Our rulers have none. And I don't even like that he called them rulers because they're not. It says our rulers have none but official, nor do they partake in the sovereignty otherwise or in any other capacity than as private citizens. This is so important. I really want you guys to internalize this. Over in Europe, say England, for instance, right? Even through the Middle Ages, the king was the sovereign, not the people, right? And so when courts were adjudicating any kind of dispute, they were, as far as the court was concerned, the judge was the king, the proxy for the king, meaning the judge borrowed a portion of the king's sovereignty to carry out that task on behalf of the king because he's just one man. He can't do everything himself, right? So the king vests a portion of his sovereignty into the court, but if the king is in the court at the same time as the judge, then now the king is the sovereign of the court and the judge is nothing, right? So that's why they wanted to get out from under kings, and that was one of the reasons why they set this country up the way they did, but they had to give us the sovereignty first, and then they took it back through administrative law by taking you under administration, placing you in a trust, offering you benefits, and you accepted them. So anyways, the king vested that portion of authority in the court. As far as anyone in the court was concerned, it was the king sitting at the bench, even though it was the judge, right? Unless the king was in the same room. Well, here we're the sovereign. The courts borrow a portion of our sovereignty to hold court and carry, and there's not supposed to even be judges. There's supposed to be justice of the peace, right? And unless it's an appellate case, but it's generally common law courts, the jury is the tribunal authority. The magistrate is the trustee that just facilitates the proceedings. That's it, and has no power whatsoever. It's a fact. You can even read that in Virginia's Bill of Rights. Magistrates are the trustees of the people and should be amenable to them at all times. Okay? So the only person who could bring you into the jurisdiction, or the only thing that could bring you into the jurisdiction of a common law court, was another sovereign. That's why it takes a signed sworn affidavit, right? A verified complaint, as they ended up calling it when they were phasing out burying it. Anyways, they can't get rid of common law, but they can bar your access to it by locking you into a trust that can only be adjudicated in equity. And that's exactly what they've done. So the only power that could bring you into the court was a signed sworn affidavit from an injured party, and it had to be a crime. Or if you contracted yourself into a trust, then you're going to end up in a court of equity, and there is a judge there, but he's still vested with a portion of our sovereignty, and we never divested ourselves of that sovereignty. This was a big problem for these people who wanted to create. The whole purpose of this country was to facilitate the creation of the One World Trust. We were the launch pad for everything. We were the launch pad for the UCC. We were the launch pad for the debt-based currency system. We were the launch pad for all of it. And what I mean by debt-based currency, because I know the Bank of England existed way before the Federal Reserve. Well, England still had, it wasn't entirely debt to a third party. You see what I'm saying? Now it's entirely debt. And by creating this system, allowed them to usurp the sovereignty of the people and expand it across the world. It's really insidious when you study it. And we're going to get into it. So my point is, originally, this problem that they had, the people were sovereign, and federal Congress, so the state government couldn't even obtain jurisdiction over the people unless another one of the sovereign people were injured by that individual, right? Then they could do the signed sworn affidavit, and then it's still the people who carried out justice. Along with this, and the fact that we were above them, and federal Congress had absolutely nothing to do with the people of the states. That's why they were given the, well, I'll get into that. But above all that, we had absolute property ownership. That's the only reason, that's the only way you can be a sovereign people, is to have if you have somebody above you charging some sort of fee or taxes or whatever the case may be for your property, then you're not the owner and you're not free. All rights are derived from property, except for the initial right, which is the right to property, which is derived from God. Okay, that's the trust, the actual real trust that exists, that they're making a counterfeit of. And all your rights are derived from property. The Latin word for estate is status or status. And your relationship to your property determines your status. So if you're a mere usufruct and a trustee, then you're indentured and you're not free. And that's where they have you now, neo-feudalism. So I'll prove this real quick for you guys, because I always prove what I say. This is the original 1848 Wisconsin Constitution. We'll go up to the top here. See, Constitution of the State of Wisconsin, photocopied in. Adopted in convention at Madison on the first day of February in the year of our Lord, 1848. We go down to Article 1, Section 14. All lands within the state are declared to be allodial, and feudal tenures are prohibited. Okay, well, some of you might be going, well, that's just Wisconsin. What about, no, see, all states entered in on equal footing. So Wisconsin's allodial title, and the fact that it's in here, having been entered into the Union 1848, which is a Confederate Union, all states are Confederate. That means the sovereignty resides within the state and therefore within the people. Now it's a corporate union they've erected over top of it. But anyways, they entered in way after, and they entered on equal footing. They were only able to put this in the Constitution because that was the case in every other state. So let's look up allodial real quick, shall we? Allodial title constitutes ownership of real property that is independent of any superior landlord. Allodial title is related to the concept of land held in allodium, or land ownership by occupancy and defense of the land. It actually comes from the old Nordic, like blood oath, all oath. It was custom way back in ancient times when you took possession of land that you would, mix your blood in with the dirt and basically have a binding oath with that land, and your blood was tied to that land, and that's why it belonged to you absolutely and to your heirs forever until you decided to alienate it. That's what allodial title is. And you just read in Wisconsin Constitution is allodial, okay? And that includes all your other property. If you had, so we're created from the dust, right? And this is the operative understanding at law, is we were created from the dust of the earth by God, right? We come from the land. We are tied to the land. Okay, that's a gift from God that's been endowed upon us. We're tied to the land. And so if you have a allodial title of your land, you're the king of that land. Nobody can come on that land and tell you what to do at all. Okay. In fact, if somebody tries to come on that land unwarranted, it doesn't matter if it's a sheriff or the president himself. and you tell them to leave and they refuse, well, you can do what you want. And there's nothing anybody can do about it because you're the sovereign. That's why the people were sovereign. That's so important to understand. All right. Now, all you get for buying a house is a warranty deed, right? You don't have no allodial title. So this is the way that land ownership went. That's not what this episode's or this stream's about, but I'm going to get into it a little bit because people are probably curious. You had a land patent. Okay. It was ceded by the United States originally, and then by the states, so after the state was right, if you were in a territory that was just a territory, but you bought land, you were given an allodial title in the form of a land patent from the United States. If you're in a state, then the land patent was issued from the state. The only purpose of the government holding land, they would hold it in trust to get it back into the hands of the people, because the people are the owners. The government is a dead thing. It can't own anything. Okay. It cannot own anything. It can only hold things. So you get a land patent. Then if you wanted to sell it, right? If you wanted to sell it, you would go and write up a deed of sale. That's what a deed is. That's why people say, hey, you got a deed to the property. A deed means something done. You would write up a deed and say, I'm selling, so-and-so, I'm selling, this land marked by the metes and bounds of, put all the metes and bounds in there. And then you'd say to so-and-so, blah, blah, blah. And you'd have a quorum of witnesses. Okay. And they would witness the sale, the exchange. It's called livery of season originally. And then they ended up putting that into disuse, but you still had to have witnesses, and then file that on the county land record. And now the deeds all have to be traced back. So no matter how many times the property sold, the deeds all have to be traced back to the original land patent. The attorney didn't like that. One, because they couldn't get in and tax the land, right? And two, because it was actually work. When there was a sale done and somebody had, or when they had to deal with real estate and they had to pull an abstract, it's called, and they had to trace the chain of title all the way back to the land patent, which is the allodial title. My point in getting into all that, though, we had allodial title. We are sovereign. That means you have absolute ownership of everything. So how did we go from that to registering and asking permission to use your property? How did that happen? Well, that's going to be the point of today's stream. The people, United States citizens, are not the people of the states, period. They're entirely two separate classes. Okay, so when you understand that they established this country to erect this world trust system, then you can see the intent behind everything they did throughout the history of the law of this nation, or this republic, rather, right? And the biggest problem they had was that Congress was given the power to mint currency. Okay. They had always planned, just like in just like in England, they had always planned to delegate that power to a private third-party bank in order to set up communism. That was the intention the entire time. They even piloted communist towns in this republic in the 1800s just to see if it would work, or if they could get people to go for it. So my point is, they had always planned to delegate that authority to a third party so that they could then take out loans from that third party central banking system. And that's how they were planning to indenture. But the issue was Congress has no jurisdiction over the people of the states at all. None. Not even a little bit. Okay. The federal corporation is basically the grandchild of the people. Okay. It's the creature of the creature of the people. The people created the states. States created the federal government. Federal government has always been an English company. Okay. We'll go over here and we'll take a look at the Treaty of Paris from 1783. It having pleased the divine providence to dispose the hearts of the most serene and potent Prince George. See, all the monarchs are princes under the Pope because it's called the Holy Roman Alliance or the Holy Roman Empire, right? By the grace of God, King of Great Britain, France, and Ireland, Defender of the Faith, Duke of Brunswick, and Lunenburg. And now here's where it gets interesting, right? Arch-Treasurer and Prince-Elector of the Holy Roman Empire, etc., and of the United States of America. Okay. The United States in Congress assembled has always been an English company. Always. It was originally the East India Trading Company. Okay. So if you're new to this channel, This might look familiar to you. This is the East India Trading Company flag. Does this look familiar? If it ever pulls up, right? Uh-oh. They're probably getting pissed. What the hell? Technical difficulties here, guys. Hold on. Well, whatever. You can see it over there. I can't even get to the damn page because I got too many windows open. But anyways, yes, it's that with the Union Jack in the center and the 13 stripes. It's the same flag. It was originally the East India Trading Company became the United States, and the intention behind these companies were to take everyone under their umbrella, become ballooned with debt from a third-party central bank, and then mortgage the citizens under their wardship to the central banking system in order to create the world trust. This is the realization of unum sanctum from 1302, the papal bull that created a world trust. This is the realization of it. Let me show you something. You're like, well, how's that? I thought it was to the central banks. Oh, it is. And check this out. Where are you, Jewish Encyclopedia? Here we go. It is somewhat a curious. So this is a Jewish encyclopedia. This is the Rothschild fluff piece, but they just can't help themselves. They have to admit what's going on here. And it says it is a somewhat curious sequel to the attempt to set up a Catholic competitor to the Rothschilds, that at the present time, the latter are guardians of the papal treasure. So who's bankrolling this whole thing? Right? The Social Security Trust is a public charitable trust. The minor account is funded by the church. It has to be, because it's a public charitable trust. So it has to be carried out by a religious organization. So it's funded by the church. That's what's going on here. Okay. So they had no jurisdiction over the people. And that was, in fact, we had the thing caged in with boundary stones in the District of Columbia. I've shown you guys these. These are actually boundary stones. On one side, it marks the jurisdiction of the United States when you're walking into DC. And on the other side, it just says Maryland. Doesn't say anything because it's all common law jurisdiction within the state. So it's no jurisdiction needs to be said. We know what it is, the original jurisdiction, common law, right? The United States operates in maritime admiralty. I'm going to show you guys how they brought that inland, actually, with the Buck Act. But anyways, they had no jurisdiction over the people. So they had to come up with a way to create a new subclass of citizen. Okay, now it's interesting. Their first attempt, well, the Civil War was obviously engineered. Then you had all these newly freed, disenfranchised, no longer slaves, but basically they couldn't survive on their own. And so the United States Corporation used this opportunity to, well, let's just put it this way. I'm sure they could survive on their own. They couldn't live in society without help, and dependency always creates servility. I can prove that too. Blackstone says it. It's basically like this: because we're all dependent creatures upon God, we must obey his will, which is laid out in the 10 Commandments and natural law, observable law. Now they took this, extrapolated this, applied it to society, and said when somebody becomes dependent on another entity, they must subject themselves to their will, insofar as they are dependent upon that entity, right? Whether it be an individual or a corporation, whatever the case may be. That's where administrative law comes in. That's how you come under administration, is dependency. And so the newly freed slaves were obviously, they just came from a situation where they had, they were provided, I'm sure it was not great at all. It's probably terrible, but they had a place to live. They had food. They had clothing or whatever. Like I said, all bad. I'm not saying they had it good. What I'm saying is they didn't provide these things for themselves. They didn't have any trades to speak of, and they were intentionally kept unintelligent for the most part, because as with the history of slavery anywhere, you don't want smart slaves, which is why we have the public education system today, because they don't want smart slaves pretty much, right? So with that being said, Andrew Johnson, their first attempt at creating the 14th Amendment citizenship, the United States citizen, was done in the Civil Rights Act of 1866, and Andrew Johnson vetoed it. And it's interesting, when you read his veto message, you can see that he knew what they were trying to do, which is why also 15 states rejected the 14th Amendment. But this was their first attempt, right? And they did get this passed, if I remember correctly, but their excuse was, well, we want to make it more permanent so a future legislature doesn't repeal it. So we want to make an amendment to the Constitution. I believe they sold this as a probationary period for the newly freed slaves, but they did it through the vehicle of federal citizenship, which up until this point, Congress had no ability to confer citizenship at all. They created uniform rules for naturalization, but it would be the states that chose to enact or chose to confer citizenship upon somebody. And that was a sacred, power that the states jealously guarded because, well, what happened. They knew it was going to happen. So here's what he said. He said, I regret that the bill, which has passed both houses of Congress, entitled An Act to Protect All Persons in the United States in Their Civil Rights and Furnish Means of Their Vindication. Now you have to look, the people had unalienable rights endowed upon them by God, not the government. The Constitution has the Bill of Rights not granting the people rights, merely prohibiting the government from transgressing them, right? Or making any kind of trespass upon them. That's what this. So people think their rights come from the Bill of Rights. No, your rights they're your common law rights, and they come from God as a free man or woman. That's where they come from, not a piece of paper. Okay, the piece of paper, everything written on those pieces of paper in the state and federal constitutions are meant to restrict the government. Anything that's written in there is something they can do or cannot do. Anything not written in there is something they cannot do at all. So if it's written in there as a restriction, they can't do it. But if it's not written in there at all, they definitely cannot do it. That's the whole point, right? Which is why the Federal Reserve's unconstitutional in the first place, because though federal Congress was endowed with the authority to mint currency, they were never endowed with the authority to delegate that authority to someone else. It's not even part of the United States, a foreign international banking cartel. Okay. We'll get into that. There's several ways we can fight these people. I'm not just bringing problems. I've got solutions. Just let me finish with the problem here. So it says, the Civil Rights Act contains provisions which I cannot approve consistently with my sense of duty to the whole people and my obligations to the Constitution of the United States. I am therefore constrained to return it to the Senate, the House in which it originated, with my objections to it becoming a law. By the first section of the Bill of Rights, persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are declared to be citizens of the United States. This provision comprehends the Chinese of the Pacific. Now, this is a really old document, and there's some pretty racy language in here, so I'm just going to substitute the language, but, you're going to read something different, right? So anyways, this provision comprehends the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, which that's an interesting one, as well as the entire race designated as blacks, people of color, blacks, mulattoes, and persons of African blood. Every individual of these races born in the United States is by the bill made a citizen of the United States. This is so important, right? It does not purport to declare or confer any other right of citizenship than federal citizenship. It does not purport to give these classes of persons any status as citizens of the states, except that which may result from their status as citizens of the United States. So it's right there. He's saying this is a whole different class of citizen. This isn't we the people. This is a person. This is a persona. This is a corporate enfranchisement, right? And don't forget that shortly after this, 1871, D.C. became a municipal corporation itself with the Organic Act and adopted a municipal charter, opening it up to international investment, which is a problem, but that's a story for another time. The power to confer the right of state citizenship is just as exclusively with the several states as the power to confer the right of federal citizenship is with Congress, which they could only do in a territory. That's it. Okay. In fact, this is such a gray area for a lot of the jurists in case law about federal citizenship prior to the Civil Rights Act or the 14th Amendment, that there's really no standard set for what that is prior to this. And that's what he's pointing out, right? So he says the right of federal citizenship thus to be conferred on the several accepted races before mentioned is now for the first time proposed to be given by law. If it is claimed by as it is claimed by many, all persons who are native born already are, by virtue of the Constitution, citizens of the United States. See, prior to the Civil Rights Act and the 14th Amendment, the citizens of the states were citizens of the United States, but not federal citizens. They were just, you would say, oh, that's a citizen of the United States. Oh, which state? Georgia. Michigan. That's a Michiganian. Because these are our countries. They were in a confederation, meaning it's a league of individual sovereign countries in a friendship with one another for mutual economic prosperity. And just so I can get this point across real quick, because some of you guys probably think, oh, he's a Confederate, blah, blah. And a Confederate is a type of union, okay, wherein the sovereignty resides within the state. And Michigan is a Confederate state, always has been, okay? It's right here. Check this out. And we'll get back to that veto message because there's a lot more to unpack in there. And don't worry, I am going to get to how to fight this, but first we got to get to what it is. You have to, in order to fight it successfully, you have to know the situation in its entirety, okay? So right here it says this is Michigan's acknowledgement of their acceptance into the Union from 1846. And it says right here, I can't highlight this, but see my cursor. Okay. It says the people of the said state are solicitous to give to her sister states and to the world unequivocal proof of her desire to promote the tranquility and harmony of the Confederacy. Because prior to the Civil War, that was the type of union. This is Michigan. Michigan wants to promote the tranquility and the harmony of the Confederacy. See the brainwashing public school has done to everyone? As soon as you hear the word Confederate, you think racist. Well, I'm going to show you exactly why it's not. This new system, this democratic system, is more racist than anything, okay? But outside of that, let's go back here. It says, by virtue of the Constitution, citizens of the United States. It says the passage of the pending bill cannot be necessary to make them such. So what he's saying is like the citizens of the states were already citizens of the United States. So you're not passing this bill to, officially declare them United States citizens. You're passing this bill to create a new class of citizen. Okay. And it says, if, on the other hand, such persons are not citizens, as may be assumed from the proposed legislation, he's saying you're showing your hand now. You're showing us that you want direct jurisdiction over these people. That's what you want. You're showing your hand. So it wasn't already that. So it says if such persons are not citizens of the United States, as may be assumed from the proposed legislation, now that you're creating, enacting a specific and distinct separate citizenship, right? To make them such, the grave question presents itself whether, when 11 of 36 states are unrepresented in Congress at the present time, it is sound policy. And look at that. It says, question presents itself whether, when 11 of the 36 states. So they tried to do this while 11 of the states were not represented in Congress, which is a violation of Article 5 of the Constitution. That's actually what we're going to use to fight this. Through courts. Courts will have to take notice of what I'm going to show you. They will have to. You do a legal brief and you put this in here and cite the case I'm going to show you, they have to take a look at it. And I'm definitely going through this with you guys in the Juris Society later on this evening. So, all right, it says it is sound policy to make, so it says, when 11 of 36 states are unrepresented in Congress at the present time, it is sound policy to make our entire, non-white population and all other accepted classes citizens of the United States. And it's a question mark. He's saying, is it sound policy? Right? 4 million of them have just emerged from slavery into freedom. Okay. Can it be reasonably supposed that they possess the requisite qualifications to entitle them to all the privileges and immunities of citizens of the United States? Now, I have to unpack this for you guys, because this is the whole BS about the 14th Amendment. Is that it gives equal protection. Yet the fourth provision tells you can't question the debt. So it was never about equal protection. And that's in congressional record as well. It was about creating a class of citizen that could be subject to Congress so that when they successfully delegate the authority of minting currency to a private third-party banking cartel, they can then cast a wide net over the entire nation and pull everyone in under federal citizenship as collateral for the public debt and create this trust indenture system we have today. That was the purpose. Now let's unpack this. He says 4 million of them have just emerged from slavery into freedom. Okay, so he's talking about the blacks, right, that were just freed. He says, can it be reasonably supposed that they possess the requisite qualifications to entitle them to all the privileges and immunities of the United States? He's talking about, in this instance, he's talking about common law rights, even though that's not the right. He's using the language out of the bill, but he's saying what the reason he's saying, do they have the requisite qualifications, is because what I told you about administration. If you cannot survive on your own, okay, if you are without sufficient estate and do not have a trade or a hobby or some other calling, right, by which you may honestly subsist. This is from the Pennsylvania Constitution of 1776. He says there can be no use in establishing offices of profit, which is a welfare office. See, because offices, they're called offices of profit because administrators are allowed to take a portion of the estate as a fee, an administrative fee of 33%, no less, right? How about that? And they're allowed to take a fee. And so it's considered an office of profit. And the reason being is if you cannot survive on your own, you have to go and appeal to, say, the township or the county at this time, back in the 1800s, township or county for assistance, then that means you cannot survive on your own. And there's that principle of dependency, right? Man, therefore, is a dependent creature, right? Let's see if I have that pulled up, actually. I want to show you guys. No, I don't right now, but I've shown Blackstone before. Anyways, man as a dependent creature must necessarily be subject to the laws of the creator. But if you're independent of all else, you have no rules to follow, such as you prescribe for yourself. It says, but a state of dependency will cause the inferior to oblige himself to the will of him upon whom he depends. So when you go and you ask for welfare, they're allowed to take administrative control of you and your entire state as if you were a child and place you under guardianship. And then they're allowed to tell you what to do, where to work, and take money from your estate, sell portions of your estate, do whatever they want, as long as it's for your benefit. Right? So that's why everything in our code right now, or everything in the United States code, not our code, is listed as if it is a philanthropic endeavor that they're engaging in. Even the space agency, for the general welfare of the United States, right? That's how every first sentence of every paragraph starts. Congress declares that the general welfare of the United States over and over and over again, because it's administrative law and it has to be for the benefit of the infants under administration. And that is and you're considered a minor or an infant. Absolutely. All right. So now that I digressed, is saying, so back to this, do they have the requisite qualifications? Are they capable of subsisting on their own, or are they going to become a charge to the states in which they live? That's Andrew Johnson's question. He's not saying they can't exercise unalienable rights because, your common law rights because they're black. He's not saying that. And that's what the enemy will try to say when we come after the 14th Amendment. They'll say, oh, you want to take away the civil rights of blacks and this and that and Mexicans or whatever. Right? It has nothing to do with that. Has nothing to do with that at all. Because people of every race can exercise unalienable rights as sovereigns under common law, so long as you are not dependent upon the state or anyone else, and you can survive on your own. And that's why he's asking this question. He says, have the people of the several states expressed such a conviction? It may also be asked whether it is necessary that they should be declared citizens in order that they may be secured in the enjoyment of the civil rights proposed to be conferred by the bill. He's like saying this could just be a probationary program. Why do you have to create a new class of citizen? And what he's really doing is peeling back the veneer behind this enactment and showing that you want collateral for the public debt. That's what you're doing. That's what you're doing, right? So he says those rights Those rights are by federal, Those rights are by federal as well as state laws secured to all domiciled aliens and foreigners. Exactly. You didn't have to even be a citizen to have your unalienable common law rights because the people are sovereign. And it didn't require state citizenship even. Just as an inhabitant, you could have a lodial title and you could have the absolute enjoyment of all of your property. And he's telling you this right here. It's in the Articles of Confederation. It's in the Articles of Confederation. It's in the beginning of the Northwest Ordinance, right? So even before the completion of the process of naturalization, and it may be safely assumed that the enactments are sufficient to give like protection and benefits to those for whom this bill provides special legislation. And so we're going to skip ahead a little bit. Okay, right here. So this is the point. The bill, in effect, proposes a discrimination against large numbers of intelligent, worthy, and patriotic foreigners. He's saying how these people who work hard to learn the laws and the customs of the country, right, and want to come and move here and become a naturalized citizen of one of the several states, right, this bill cuts all these other people who are not qualified because they do not know how to be independent and they do not know the laws and customs of our nation to jump ahead of those people, right? He says and so he's saying, in favor of the black, to whom after long years of bondage, the avenues of freedom and intelligence have just now suddenly opened. So what he's saying here, and this is so important, is he's saying it's not because they're black that they're not able to exercise unalienable common law rights, right? The reason is because they've just now become free, and the doors, the avenues to learn how to build their house, right? And what I mean by house is the house of your seal, your house, your established legal presence in the state as a sovereign house, right? That's why the Rothschilds have a house, the Rockefellers have a house. All these people have houses still to this day, but that knowledge has been taken away from you because they don't want you to have that legal protection, that shield. Right? I have a house. It's established. It's on the public record. It's the House of Wells. I have a seal also, right? It's on my nightstand. Use it all the time, right? So it was so commonplace, even up to this time, to have a house and seal, because if you were truly free and sovereign, you had a house and you had a seal, and you could also hold your own court because you had a house and a seal and you were sovereign. At common law, you could hold your own court. So the original Illinois state constitution and the schedule, when they're laying out how to enact all the portions of the constitution, create the government, it says the governor shall use his private seal until a state seal can be made. What does that tell you? That means that anyone who is eligible to be governor, meaning a free man, and one of the people of that state, anyone who is eligible to be governor had his own seal. It was common, right? And so what he's saying here is the doors of freedom just opened up to them at this point in time, and that they could learn to be free. You don't need this 14th Amendment. There's nothing discriminating against them from, becoming free. So that's pretty much what I want to show you. He adds on he says exactly what I just said. Says he must of necessity from his previous unfortunate condition of servitude be less informed as to the nature and character of our institutions than he who coming from abroad has to some extent at least familiarized himself with the principles of a government to which he voluntarily entrusts life, liberty, and pursuit of happiness. So what he means by institutions, you have to know the common law. Like right now, if you don't know the common law, you don't know what law is, which is pretty self-explanatory. Do not violate the will of another, but you also have to know how to bring suit against somebody or protect yourself in suit against somebody. That's why you would have a house if you're one of the people, because that is your very first layer of legal protection is the house. And then you could have a trust on top of that, right? But the house is basically the first trust, the original trust. But anyways, they could be free if they learned how to do this thing, right? So he's saying that this amendment was entirely unnecessary, and it's very important. So let's move on. So we'll look at Black's Law 4th edition real quick, just so I can show you that even back in the day, they admitted Black's Law 4th edition. Of course, it's at plenary again for whatever reason. I don't know why it doesn't stay where I open it at like it used to, but bear with me for a second, guys. I'll get there real quick. I've done this quite a few times now. Okay, oops, up a little bit. Okay, it's gonna be right down here. It's the 14th Amendment. It's right here. Nope. Thought it was. Right here, 14th Amendment. So we're gonna zoom in on this. It became part of the organic law, July 28, 1868, and its importance entitles it to special mention. It creates, or at least recognizes for the first time, a citizenship of the United States as distinct from that of the states. So this citizenship is a trust office because it's offering to grant privileges and immunities to persons who otherwise would not be able to exercise common law rights. So they call it civil rights to confuse you, but it's not a right at all. It's privileges as a result of a trust arrangement, right? So basically their entire estates, all 14th Amendment citizens from the start, your entire estate and the administration of it is settled with the federal corporation. Settlement means to convey the right of an estate for the benefit of some person or persons. It's settled with the federal corporation. They then take over, and this is how they can protect your privileges and immunities because you're basically their ward. Not even basically, you're actually their ward, and they are your guardian. And this is how the doctrine of parens patriae gets implemented, or government as parent, in case you didn't know what that meant. Okay, this is how it gets implemented. And you become their ward. And now, as part of this trust arrangement, you're to use the property how they tell you to use it, right? All the property that you acquire, and you have to do what they tell, and they have the administrative right to mortgage any portion of your property if it is for the best interest of you or the estate, right? In exchange, they offer you these privileges within the states, though you are a foreigner to the states. It offers you privileges within the states. And there's a whole bunch of cases that arose out of that, like Hendricks v. Maryland, where the question is like, how do you have the right to tax somebody just because they come from the District of Columbia and they're traveling through your state? You know, and this is how licensing and all this stuff started to be issued, but that's a story for another time. Offering privileges and immunities within the states in exchange for your autonomy, your sovereignty, your autonomy, and your right to question the public debt. Let's take a look at the 14th Amendment for a second, shall we? I know I have it pulled up somewhere. Got a lot of tabs, forgive me. Right here. Okay, so it says all persons. So whereas the Constitution begins, we the people, the 14th Amendment begins all persons, because persons are not people. Person is a persona. It comes from the Latin persona, which is a mask or a character. Okay, and that's because the 14th Amendment citizen is an office of trust. You can look at it as if you are an officer, an employee of the United States Corporation, because that's definitely how the states look at it via the Buck Act. I have that pulled up for you too. But all persons born or naturalized in the United States and subject. Now, remember what we've seen over here in Chisholm v. Georgia? It says that the governors are agents of the people and at most stand in the same relation to their sovereign, meaning the people, in which the regents in Europe stand to their sovereigns. Okay, so the governments are subjects of the people. So the state governments are subjects of the people, and the federal government is supposed to be subject to the state and can only exercise the authorities granted to it. Now, this amendment creates a trustee, right? It's a creature of law that is subject to the United States. Now, remember, the United States is a crown company, has always been a crown company, and now you're subject to the crown again, just like that. Bam. Just like that. Okay. And it says, no state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States. So those are not rights. Those are civil rights, which are privileges and immunities. They can be granted and they can be taken away. Very important. Yeah. Pat says we have billions of arms and trillions of rounds. Yeah. We go ahead and keep doing that in the chat. I'm not going to really be able to say a whole lot of that on the stream, but all right. It says, nor shall any state deprive any person of their life, liberty, or property, with etc. Right, blah blah blah. But basically, the key word in that first section is subject and persons. Keywords: persons and subject. Now you're subject to something that had no jurisdiction over you in the first place, or the states had no jurisdiction over the states. This 14th Amendment is how they erected jurisdiction within the states via contract. So it's like an overlay. It's not technically within the states. You could look at it as it's like laid over like a clear sheet of glass, and you can contract into this film of United States jurisdiction, which is what most everyone has done until you take yourself out of it. Now, this is supposedly an equal protection law, right? Okay. What is this doing in it? Like I told you, the 14th Amendment was established to give Congress a pool of agricultural chattel collateral, right, that they could use to take out loans from private third-party central banking cartel. That's it. And that's exposed right here when it says the validity of the public debt of the United States, blah, 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 shall not be questioned. What? Shall not be questioned? What could have been their intention behind that? Could it be this, maybe? Right here? Oh, sorry, not that one. This. Right here, where they mortgaged your estate, and it's right in congressional record. So you can't question the mortgage of your estate if you're a 14th Amendment citizen. Well, that's why we don't question the mortgage of the estate of the 14th Amendment citizen. We challenge whether or not that even applies to us at all, because we're not 14th Amendment citizens, period. In fact, the 14th Amendment is entirely invalid, but I'm getting ahead of myself a little bit. So let's go back here to Government Printing Office. This is House Congressional Record, June 13th, 1967. Now, this is where I found this very interesting, well, I should say we found in the Jurist Society, this very interesting portion of the Congressional Record. Now, I had read, I'd say half of this many times, picked out what was important for what I'm teaching, because, yeah, it's enshrined in Congressional Record. It's a discussion of Congressional Record, but it's not like this is going to persuade a judge. So I never had read the whole thing until I was reading through it the day before yesterday when we were having our Jurist Society meeting. And I came across something I'm going to show you here in just a few moments. But first, let me show you the title of this thing. Well, hold on. Let me make sure I got the page that I'm coming back to is 15645, right? Yeah. Okay. So we go up to 15641. And again, the citation for this is House Congressional Record. So make sure you look up specifically House, right? June 13th, 1967, page 15643. Or, I mean, you can email me. I've got PDFs of this, so obviously. And the Jurist Society has access to all of this stuff because it's all in the Jurist Society folder. So you guys are good. But anyways, so we're going to go up here. What is this Congressional Record called? The 14th Amendment, equal protection law or tool of usurpation. Well, it was obviously a tool of usurpation. So look at the way that they enacted this thing. The 14th Amendment, or the Civil Rights Act, Andrew Johnson vetoed, but it still passed. And then they're like, hey, we need to make this more permanent. Otherwise, they're going to take away these poor people's civil rights, right? Which was a load of shit. They didn't care about civil rights. They cared about having collateral for the public debt. So, they were like, we need to enshrine this as an amendment to the Constitution so it's permanent. No future legislature can repeal it. Well, obviously, all the states ratified the 13th Amendment, had no problem with that. Yes, slavery's bad. Get rid of it. Done. No problem. Okay. The 14th Amendment, on the other hand, the states weren't so keen on. Okay, so the 14th Amendment's unconstitutional. I've shown you guys this before. It says it needed a 3/4 majority. It did not get a 3/4 majority, right? It says over here, it shows you all the different states that rejected the 14th Amendment: Texas, Georgia, Florida, Alabama, North Carolina, Arkansas, South Carolina, Kentucky. Now, not just southern states, though, because we have Delaware, Maryland, Ohio, New Jersey, as well as Virginia, Louisiana, Mississippi, right? They all rejected it. And the reason being is for the same reason Andrew Johnson vetoed the Civil Rights Act, and he also vetoed this 14th Amendment, is because it purports to give Congress the right to confer a new class of citizenship when that was never granted to them by the Constitution originally, and for good reason. It was a safeguard to keep the people from being collateralized as the people in England were under the Bank of England. They weren't stupid. There were some good people in our government, right? That's why we started with freedom in the first place. In fact, John Adams said this. He said, "Our Constitution was made only for a moral and religious people. It is wholly inadequate to the government of any other," because the government had no authority over the people. Only other people did in the form of a jury, right? So Congress was not given the right to confer citizenship. This is actually enshrined in an ex parte motion right here called ex parte nulls. It says the power to naturalize is not, sorry, cat irritating me. Anyway, the power to naturalize is made a judicial power by act of Congress. Congress cannot confer any judicial power upon a state court. So the provision of the Constitution of the United States, which gives Congress the power to establish an uniform rule of naturalization, is construed to mean that the rule, when established, shall be executed by the states. Now, obviously, this is just prior to the Civil Rights Act and 14th Amendment by about 12 to 14 years or so. But ex parte means single party motion, right? And they wanted to get this on the record for good reason. They could see what was coming, I think, right? So he says this, every court of record. So it takes a court of record within a state to confer citizenship upon somebody. And it says that Congress has no right to do that, right? It says the legislature of California has, by express enactment, conferred jurisdiction on district courts of the state, which were all common law courts of record, to grant naturalization according to the rules established by Congress. It shows you right here, it has to be a common law court to confer jurisdiction. It says every court of record in any individual state having common law jurisdiction and a seal and clerk or protonotary shall be considered a district court within the meaning of this act, which they could naturalize, right? It says all other courts of the state being courts of inferior and limited powers, which is that's the only thing that there is now. The only court of record in the whole republic is in DC, and it's the Federal Court of Claims, and it's all you got really, right? Which is why we have to do this. So, and although some are courts of record, yet having only statutory and common law jurisdiction, they have no power to grant naturalization. And any attempt of the kind by them would be basically non-judicial and void, right? So back to this public record here, or congressional record. So you see that the states rejected the 14th Amendment because it was unconstitutional from the start. Congress was intentionally not given the ability to create its own class of citizen for the express reason that it could not collateralize the people and then indenture them through debt. Okay. So we're going to go down here to the most exciting thing about this congressional record that we at the Juris Society just found the other night. It says the defenders of the 14th Amendment contend that the U.S. Supreme Court has finally decided upon its validity. Such is not the case. Right. So it's saying, and I've had lawyers say that to me too, because I always use the 14th Amendment. You attack, that's your only chance. It's the only nexus of attack. The only point of attack is the 14th Amendment, because without the 14th Amendment, you could keep all the Federal Reserve, the bar associations, you could keep it all, the IRS and everything, but you remove the 14th Amendment and this entire parasitic beast will shrivel up and die with nothing to feed on. It is the 14th Amendment citizenship that gave Congress the ability to mortgage the estates of the 14th Amendment citizen to the central bank, which created this administrative system where now all your properties registered, your automobile, your land, your boats, whatever, right? Even your firearm, or they're not even firearms, a commercial term, your arms are registered, right? Which makes it property of the state, and you just have the right to use it because it's been mortgaged. Okay, so now it's under administration. All these courts are part of the Federal Reserve System, and they're collecting the rents and profits from the estate while the loan is outstanding because it's in mortgage. This is part of the law of mortgage. If you don't know that, go watch my earlier streams. I'm not going to digress into all that on this stream here. But so the cop is a pirate creating an attachment to the public trust, which is the social security number, and using that as surety to generate, for the court to generate its own commercial paper, which is negotiable instruments, debt securities, in order to sell them to institutional investors. That's the name of the game. I call it securities farming, right? I call it securities farming. I think that's exactly what it is. So anyways, I had these lawyers. I've had them say, the Supreme Court has declared that it's valid. No, they haven't. And this congressman actually lays it out for us. It says the defenders of the 14th Amendment contend that the U.S. Supreme Court has finally decided upon its validity. Such is not the case. In what is considered the leading case, Coleman v. Miller, right, 307 U.S., which I actually have pulled up, the U.S. Supreme Court did not uphold the validity of the 14th Amendment. And that's from 1939, and it did not. And I'll show you the case, but he goes through pretty much the most pertinent parts. It says, in that case, and this is what they did too. I read it. I was reading the case. It says, where's my cursor at? There it is. All right. In that case, the court brushed aside constitutional questions as though they did not exist. For instance, the court made the statement that the legislatures of Georgia, North Carolina, and South Carolina had rejected the amendment in November and December 1866. New governments were erected in those states. Listen to this. New governments were erected in those states and in others under the direction of Congress. Listen, they admit it in this court case. I'll show you. This is right from Harvard Case Law Access Project. Look. So this isn't just something this congressman is saying. The courts actually admitted this, right? And they admitted something else I'm going to show you in a few moments that is just, when you put this in a legal brief challenging jurisdiction, when they try to give you a traffic ticket, the court has to take note of it because this is a judicial question. This is a judicial problem. Okay, not only that, but it's something the Supreme Court long since should have taken a look at. But check this out. 14th Amendment, right? So this section right here highlights, it says it has been applied repeatedly in cases where municipal corporations have challenged state legislation affecting their alleged rights and obligations. Being but creatures of the state, municipal corporations have no standing to invoke the contract clause or the provisions of the 14th Amendment of the Constitution in opposition to the will of their creator. And that's the maxim that makes the people sovereign. Okay, the government, the state governments are creatures of the people and have no right to impose their will over the will of their creator. So they did this crafty 14th Amendment BS. But anyways, check this out. So the next little section is the one. It says the legislatures of Georgia, North Carolina, and South Carolina had rejected the amendment in November and December 1866. New governments were erected in those states. New governments were erected in those states. And what they're not telling you is they sent the military into those states, forcibly removed the sitting and duly elected members of those governments, and then installed their own proxy governments under orders of federal Congress. That is a direct violation of Article 5 of the Constitution. This is a direct violation of Article 5 of the Constitution. That may not mean much to you, but as somebody who does legal work quite often and write and drafts briefs and motions, stuff like that, right? Well, actions, not motions. I don't play in equity, but actions, right? This is huge. This is a huge problem for them. So it says the new legislatures ratified the amendment, that of North Carolina on July 4th, 1868, that of South Carolina on July 9th, 1868, and that of Georgia, July 21st, right? It says, and the court gave no consideration to the fact that Georgia, North Carolina, and South Carolina were three of the original states of the Union with valid and existing constitutions on an equal footing with the other original states and those later admitted in the Union. And see, that's why I said Wisconsin having a allodial title in their constitution shows you that all land is allodial here in the Republic because of the equal footing doctrine. Okay, so they wouldn't be able to put that in their constitution in 1848 if it wasn't the case already. But anyways, What constitutional right did Congress have to remove those state governments and their legislatures under unlawful military powers set up by the unconstitutional Reconstruction Acts, which had for their purpose the destruction and removal of these legal state governments and the nullification of their constitutions? Right? The fact that these 3 states and 7 other southern states had existing constitutions, were recognized as states of the Union again and again, had been divided into judicial districts for holding their district and circuit courts of the United States, had been called upon by Congress to act through their legislatures upon 2 amendments, the 13th and 14th, and by the ratifications had actually made possible the adoption of the 13th Amendment, as well as their state governments having been reestablished under presidential proclamation. So Andrew Johnson restored them to their previous status before the Civil War. Said, okay, back to business as usual. Right. And when they rejected the 14th Amendment because it is an instrument of slavery and they've seen it, it doesn't give rights. It takes them away. OK, it takes them away. I'll show you another case real quick just to illustrate that point. This is USV, or no, I'm sorry. It's the one I want is not Hendrick. Maxwell v. Dow. Where's Maxwell v. Dow at? What the hell? I know I have it up here somewhere. Did I take it down? I probably put it on a different page. Let's see if I can pull it up real quick. Yep, sure can. Okay. Maxwell v. Dow tells you that the privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of federal government. Now, why do you think that would be? Because they're not the people spoken of in the We the People preamble. So they don't, that's why a judge in these administrative courts will tell you, right? You go in there and say, well, this is unconstitutional. I have the common law right to travel. And they'll be like, listen, the Constitution has no place in this court. And he's right, because that court is an administrative hearing. Okay. It's actually a bank and it's part of the Federal Reserve System. And it's holding an administrative hearing, compelling a trustee to answer under oath for the misuse of the set decay trust, or the property of it, rather. That's what's actually going on. And you don't have privileges and immunities guaranteed by the 8 amendments of the Constitution, which are actually just guaranteeing the common law rights. It doesn't grant you anything. It just tells the government, like, hey, these people are under common law. You can't do these things. They're not entitled to that because they're not under common law. They're under administrative law, and they do not have common law rights. And therefore, the Constitution, the Bill of Rights, does not apply to them. It's a whole different class of person. That's why it's so important to get rid of this damn thing. So it says, as shown by Andrew Johnson's veto message, that he restored the states to their previous status, right? And proclamations were all brushed aside by the court in Coleman v. Whatever I just told you it was called, Coleman v. Miller. Yeah. New governments were erected in those states and in others under the direction of Congress and by military force. That's why when Andrew Johnson vetoed this, I'm going to show you guys something. This is his veto message. If ever the American citizen should be left to the free exercise of his own judgment, it is when he is engaged in the work of forming the fundamental law under which he is to live. That work is his work, and it cannot properly be taken out of his hands. All this legislation proceeds upon the contrary assumption that the people of each of these states shall have no constitution except such as may be arbitrarily dictated by Congress, right? The common misconception is that prior to this 14th Amendment BS is that the state constitutions had to be a reflection of the federal constitution. That's not true at all. Okay. The only thing the state constitution had to be in accordance with was the common law. Understanding that the people are sovereign, the people that were creating their constitution. So what the Constitution did was laid out how government would function and who would control what aspect of business, of trade and relations with other states. That's it. Your rights are never meant to be legislated. But the federal corporation could not tell the states what to put in their constitution before the 14th Amendment. And that's what he's saying. And so he's saying, all this legislation proceeds upon the contrary assumption that the people of each of these states shall have no constitution except as may be arbitrarily dictated by Congress and formed under the restraint of military rule, which is where we still exist today. Lieber Code was never properly lifted, which was the martial law of the Civil War era. Okay, yes, exactly. Say what? That's going to be civil Roman codes and statutes. And sorry, guys, if I'm not paying enough attention to the chat. This is a lot of information we got to get through here, so I'm just trying to get through it. You know what I mean? So 645. So here's where we are. It said, says in Coleman, or wait, where were we? Yeah, and that the new legislatures ratified the amendment. Okay. The U.S. Supreme Court. So you have to look at this. Well, he'll lay it out, but you have to look at this. These states rejected the amendment. All the states that rejected the amendment, government sent the military down into those states, forcibly removed their duly elected government officials and replaced them with stooges of the federal corporation to get this amendment ratified. Can you say absolutely unlawful? It is invalid. That does not, and this is how you make the legal argument, right? It says in Coleman, or it says the U.S. Supreme Court overlooked that it had previously held that at no time were the southern states out of the Union in White v. Hart. That's huge. That is huge. Okay. And that's from 1871. And Coleman, so you need White v. Hart too in combination with the Coleman v. Miller, because that shows that, well, how did they go in? So the legal argument against the invalidity of the 14th Amendment, meaning in support of it, in support of its validity, they would say, well, those states were in open rebellion. But in a subsequent court case, White v. Hart, they said, no, at no time were the southern states out of the Union. So then what were you doing sending the military down there to install a puppet government in place of the duly elected one by the people of those states? What were you doing? Committing a crime because you're a bunch of thugs and gangsters working for the Jesuits and the fucking papacy, excuse my language, but that's what it is, right? And I get a little heated about it. And the Rothschilds, make no mistake, that's why I say all the time, the Rothschilds, it's all just one big ancient Babylonian money magic cult, death cult. That's what they are. And they go under the veneer of various different religions, but really it's just the same old ancient Moloch worshiping religion that's behind this. And they're all in on it. Whether they be small hats or they be, whatever, the Jesuits, on and on, right? So it's all about but we're not getting into that. So let's continue. All right. In Coleman, the court did not adjudicate upon the invalidity of the acts of Congress, which set aside those state constitutions and abolished their state legislatures. The court simply referred to the fact that their legally constituted legislatures had rejected the 14th Amendment and that the new legislatures had ratified the amendment. Okay. The court overlooked the fact, too, that the state of Virginia was also one of the original states with its constitution and legislature in full operation under its civil government at that time, right? The court also ignored the fact that the other 6 southern states, which were given the same treatment by Congress under the unconstitutional Reconstruction Acts, all had legal constitutions and a Republican form of government in each state, as was recognized by Congress, right? So I'm not going to bore you guys with the specifics of that, but this is the point, and this is what needs to go in the legal brief. In fact, it needs to go in a legal brief and sent to the Federal Court of Claims, probably, right? It says all this was ignored and brushed aside by the court in Coleman's case. However, in Coleman, the court inadvertently said this, and this is where they screwed themselves. Whenever official notice is received at the Department of State that any amendment proposed to the Constitution of the United States, let me go up here, proposed to the Constitution of the United States has been adopted according to the provisions of the Constitution, the Secretary of State, what the hell? Get out of here. The Secretary of State shall forthwith cause the amendment to be published with his certificate specifying the states by which the same may have been adopted, and that the same has become valid to all intents and purposes as a part of the Constitution of the United States. So the problem with that, The problem with that, Carson Russell asked what book or article. This is House Congressional Record, June 13th, 1967, page 15641 to 15645, if that's what you're asking. But Article 5 says that, so right here, we got in Hawk v. Smith, US 221, right? The Supreme Court unmistakably held that the fifth article, this is important, the fifth article is a grant of authority by the people to Congress. The determination of the method of ratification is the exercise of a national power specifically granted by the Constitution. That power is conferred upon Congress and is limited to two methods by action of legislatures of 3/4 of the states, right? So that's the current, that was the original and current's never been changed method of ratification, is it has to be ratified by three-quarters of the states then in the union. Okay? Has to. There's no other method, which means there's no going in, removing a government that doesn't want to ratify it, and then putting your own puppet government in so you can get it ratified because you need it to be ratified in order to establish the central bank and then create a national trust, aka communism, and then expand that into a world trust and make it digital with AI governance and digital ID and digital currencies. All of this falls apart without the 14th Amendment. There's nothing they can do. If we attack this and we stand on it, every time you have an interaction in the courts, don't let it get past arraignment. I'm not a 14th Amendment citizen. In fact, the 14th Amendment isn't even a valid amendment to the Constitution. The courts never upheld the validity of it, and then you can explain everything. And then aside from that, let us not forget that it's voluntary, right? So not only is it voluntary, but it's invalid. Here it's voluntary. You can go bring up McDonald v. State. Always bring up McDonald v. State. Indiana Supreme Court, right? Indiana 320 from 1883, May 15th. And you go down here, and basically the story behind this case is that this guy was convicted by a jury of his peers. Okay. The word peer meaning sovereign. He was convicted by a jury of his peers, and he appealed it and said, well, one of the jurors wasn't a United States citizen. He came from Germany. He shouldn't have been on the jury. Well, they rejected his appeal, and this is what they said. They said the evidence of bushing on his voir dire, which is a competency examination for jurors to see if they're capable of being a juror, says the evidence of bushing on his voir dire that showed that although he was not a citizen of the United States, he was a citizen and voter of the state. Under Section 2 of Article 2 of our state constitution, one may be a citizen of a state and yet not a citizen of the United States. And that's also upheld in Thomason v. State, Corey v. Carter, McCarthy v. Frolke. See, this is why they don't want to use any court cases before 1939. And in fact, this is interesting. I think this is why. Look, I've checked out dozens and dozens of cases from Harvard Case Law Access, but this one that shows that they've never upheld the validity of the 14th Amendment is blacked out like a CIA document, dude. I shit you not. Check this out. You go to the scan PDF. Look at this. Look at this. I've never seen this on a court case. Never. This is blacked out like it's a CIA document, dude. This entire case summary here, so you can be sure that whatever case summary you find on Justia or whatever is not the case summary, right? This case summary is blacked out because this entire case is questioning another amendment, the Child Labor Protection Amendment, right? That Kansas didn't want to ratify for whatever reason. I'm going to look into that. It's probably something related to some Epstein-esque CPS type stuff that they were able to establish, because make no mistake, Epstein may have been a monster, but he's got nothing on the U.S. government. He's got nothing on the U.S. government, or really any government right now, especially when you start talking about U.S. and Israel, all that stuff, right? Epstein didn't have shit. He was a little guppy in the pond compared to these people and their CPS and all that stuff. So just so you keep that in mind, and I bet it had something to do with this, but I've never seen a court case blacked out like this, guys. I've never never seen a court case blacked out like this, and it's pretty wild. So you got the Hendricks v. Maryland shows you, right, that, or not Hendricks, I meant, what the hell, the Maxwell v. Dow. It's a very important case. I showed you guys that. Tells you that the 14th Amendment citizen, or the citizen of the United States, isn't even entitled to the protections of the Bill of Rights. Yet you want to invoke it all the time when you go into a courtroom. No, you need to challenge the 14th Amendment. So this is blocked out because this very much admits that they have never upheld the validity of the 14th Amendment. And in fact, they are being negligent in their duties and not ruling on the question of its validity, given the fact that the United States at gunpoint took out the state government and replaced it with its own puppet. Indirect violation of the 5th article of the Constitution, depriving that state of its equal suffrage in the ratification process. And that legal argument right there is something a court cannot ignore. It cannot, because that's the Supreme Court's whole purpose is this, supposedly to rule on the constitutionality of, or unconstitutionality of, specific actions done by the government. Well, there's no getting around this one. There's no getting around this one when you forcibly remove their government, right? The case blacked out. Yeah. So there's just one specific thing. Carson Russell asked. The case that was blacked out is Coleman v. Miller from 1939. Okay. And its specific citation is, I'll actually have to go back because it's all blacked out, right? Is 307 U.S. 433, right? But what was interesting about that, there's been some weird stuff going on with that document because it's cited. It is the same case being cited because the exact citations are in this congressional record. But what he had cited it as was 307 U.S. 448. So something's been shifted with that document. Probably has to do with it being blacked out, right? And you need to know what to take out of it because I highly recommend people get it. That document, you can go to Harvard Case Law Access Project. Just put in Case Law Access Project. Has every court case ever from even before we were a republic, back when we were colonies. It's an awesome resource. Don't know why they did that. Probably because they have to. But what you wanted to show is two things, right? Is that it admits that the United States, the Congress, sent the military. Well, it doesn't mention the military, but that is what happened. That the United States forcibly removed the duly elected legislature, or the duly elected governments of these states that rejected the 14th Amendment, and replaced them with their own puppet government to get the 14th Amendment ratified. And that's in direct violation of Article 5. And he even says that, you know, when the Secretary of State, says right here, whenever the Secretary of State receives any notice that an amendment proposed to the Constitution of the United States has been adopted according to the provisions of the Constitution, Secretary of State shall. So he's saying if he has to receive notice that it has been adopted according to the provisions of the Constitution. And this right here in that case, Coleman v. Miller, admits that it was not. And they didn't mean to, because it was in 1939, but that judge definitely screwed up when he admitted that. So he goes on to say, this congressman, he says, we submit that in none of these cases in which the court avoided the constitutional issues involved in the composition of Congress, which adopted the joint resolution for the 14th Amendment, did the court pass upon the constitutionality of the Congress, which purported to adopt the joint resolution for the 14th Amendment. With 80 representatives and 23 senators, in effect, forcibly ejected or denied their seats and their votes on the joint resolution proposing the amendment in order to pass the same by a 2/3 vote, as pointed out in the New Jersey legislature resolution on March 27th, 1868. And so it's funny, from what I gather, what happened was originally, like New Jersey and Ohio, they had approved the 14th Amendment, right? But then when they seen those southern states reject it, they seen what Congress did. And when they seen that Congress sent the military down there to forcibly remove those duly elected government, they rescinded their approval. They're like, no, they did it. They amended it and they said, no, we reject it. Whatever you guys are trying to pass that for, if you're willing to do that, we want no part of it. Well, guess what they were trying to do with it? This right here. Whoops, not this one. My bad. This one. The money will be worth 100 cents on the dollar because it's backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. Congress could only act as a proxy settler of your estate to the private central banking cartel if they have jurisdiction over you and the administrative authority to do so by being your guardian, which they are. And that's why they can tell you, wear your seatbelt, little infant. Don't you smoke that weed, little infant, right? They can tell you what to do with your property, your body, everything, because you are a trustee of the federal corporation. You are a enfranchisement of the federal corporation, which brings me to the Buck Act, because I got to get into that real quick. I got the Buck Act is, where did I put that sucker? Right here. Oh, wait, no, this is how they do. Well, yeah, all right, we're going to do both of them. So this is the Buck Act. So what the Buck Act did, by making you a 14th Amendment citizen, they were able to classify you as federal property within the state, as an enfranchisement, right? And technically, you're a business, right? So what do you mean I'm a business? How am I a business? Well, let me show you. That's person, human being, location of debtor, rule number 2, 14th Amendment. Where did I put that business one? That's motor vehicle. Well, the United States citizen is a business. So let me show you. I'll prove it in just a second. It should have been up here already. That's why I use this page with a million tabs, because everything I look up is in here. So, okay, well, guess what? We'll just do a new one. So, U.S. business defined. 15 U.S.C. Section 470, Section 4724 says the term United States business means a United States citizen. So you're a business, you're an enfranchisement, you're a widely held fixed investment trust, you're federal property within the state, and everything that you do is considered commercial, according to them. That's how they can require the license, right? So driving, that's an interesting thing. I plan on doing a whole thing on driving. Driving, actually, the word driver comes from a time when generally people would hire somebody to conduct their coach or carriage. And when they did, for profit, it's one employed to conduct a coach or carriage. It's in Black's Law, 4th edition, under driver. And look up driver in Bouvier's 1856, which is adapted to the common law. And driver is an employment. It is a business. It's a trade. So because it's a business or a trade, and you're considered an enfranchisement there to do business under the authority of the United States, right? So what these administrative agencies are, let me get into the Buck Act, because that'll make it make more sense. Let me get into the Buck Act. So it says, no state or political subdivision thereof shall have the power to impose for any taxable year ending after the date of the enactment of this act a net income tax on the income derived by such state or within such state by any person from interstate commerce. If the only business activities within such state are on or behalf of such person, then they lay out a couple exceptions. And this is specifically for the courts. The solicitation of orders by such person or is representative in such states for the sales of tangible personal property. And then down here, it also includes intangible personal property. I'm not going to bore you with all the lingo, but that's how the courts are exempted. Okay. And they're not taxed on the securities that they generate and trade in, because a solicitor, when you look up the definition of a solicitor, it's quite interesting, actually. Did I bring it over here? I think I did. A solicitor is a lawyer, and it's a type of lawyer, right? So when you look up this, it says it's a type of lawyer that can only operate in equity. And remember, all trusts are adjudicated in equity. The 14th Amendment is a citizen is an entirely trustee position with only equitable rights to the property he or she holds in trust, because it's also held in trust as collateral for the public debt. But even without that, you'd still only have equitable rights because it is a trustee position. That's how they're able to have administrative control of the mortgage or estate. Now, I'm not going to beat that horse dead, but you're trapped in equity, right? So solicitors can only operate in equity. It says this right here. It says solicitors were lawyers. Here, let's see if I can highlight it. Solicitors were lawyers who were admitted to practice in equity courts, whereas barristers were lawyers who practiced in common law courts. The modern English judicial system has abolished this distinction. So has the American, because they have trapped everyone in trust. They've created national trusts using the central bank and converting the currency to debt, and then mortgaging the estates of all the citizens to be held as collateral. So, or to be used as collateral held in trust. So they abolished, but you can't get rid of common law. But that's why they call them solicitors, because they are soliciting in equity. Now we look up solicitation. This is where it gets interesting, right? We look up solicitation. Urgent request, plea, entry, and enticing, asking, the criminal offense of urging someone to commit an unlawful act. A person who asks someone to commit a legal act has committed the criminal act of solicitation. An employee who agrees in an employment contract not to solicit business after leaving her employer and then mails a letter to customers asking for business may be sued. So that's solicitation. They're asking you to do something. That's what they're doing. So when we read the Buck Act, these courts, it reveals that what these courts are doing, whoops, that's not the Buck Act, is it? No, it's this one. What they're doing, the solicitation of orders by such person, right? It's an offer. It's a presentment. They're soliciting. They're soliciting in equity. So go down here. Now, the interesting thing is that it sets these exemptions, the Buck Act does. And this was very hard to find, by the way, guys. I'd been looking for this for a long time, and I finally found it. Straight from the U.S. code. What you have to do, obviously, and I should have done it a long time ago, is not go by its common name, Buck Act, but look up the public law number 86272. Make sure you do for the U.S., not because it'll bring up state laws 872 too. But anyways, so check this out. It says the provisions of subsection A shall not apply. So these is right. Subsection A right here is telling them what they're not allowed to charge income tax to. Right. And this one says who it doesn't apply to, so that they can charge income tax. And it says any corporation which is incorporated under the laws of such state, which is the United States territorial jurisdiction. Right. And it says, or any individual who under the laws of such state is domiciled in or a resident of such state. It's the resident. Right. You never hear your governor say Michigan citizens or Florida citizens, or what they would really say is Michiganians or Floridians, because that's the actual nationality. They say residents. And why is that? Because a resident is a foreigner. Okay. Now you'll notice this right here. This is resident from the Motor Vehicle Code of Michigan. It says means every person who resides in this state, lowercase s, meaning Michigan, right? Not capital S state, meaning the United States territorial jurisdiction or the enfranchisement of that, the state of state. Anyway, resides in the state and establishes, right there, then word's important, that he or she is legally present in the United States. So it means you reside in this state, but you're legally present in the United States. Now, let me elucidate that a little bit more for you guys so you can really get the idea here. This is a treatise on law called Elementary Law Smith. Okay. This section right here, members of a state, it tells you, it says a member of a state may either be a citizen occupying the status entitled citizenship, or he may be a resident alien occupying the status designated by the title residence. So residence is foreigner. You're a foreigner. You're a resident alien. A citizen is a permanent member of the state, right? The status of his membership Citizenship is distinguished by its permanent and personal nature. So you're part of the land, therefore you're under the law of the land, right? So this here says that a resident alien, on the other hand, is a person residing within a state other than the state of which he is a citizen, because you are a citizen, really an enfranchisement of the federal corporation, which is headquartered and located for all intents and purposes in the District of Columbia and is foreign to the state. That's why so what they did was they made the 14th Amendment all pervasive and then put the state citizenship into disuse, because if they did not do that, you would still be one of the people. And then you'd be able to do all this acceptance for value stuff that everyone's talking about, right? That what you can't do as a 14th Amendment citizen. The only way that you could do it is if you were actually one of we the people and not an agent of a debtor principal that's bankrupt. And as a foreign corporation, you have to be one of we the people. Then you could discharge debts through the Treasury, but they'll never do that anyway. So I wouldn't even tell people they're supposed to. I'll agree with that, but they won't. And one of the reasons that they do not is because they don't recognize you as one of the people of the states. But they would have to, because of the just compensation clause with the government taking property. If they cannot take property without giving you just compensation. So they would owe you regular payments of interest and dividends from the mortgage of your estate if you were one of the people. So they had to put state citizenship into disuse, right? So it says this: a resident alien, on the other hand, is a person residing within a state other than the state of which he is a citizen. The status of his membership residence is distinguished by its temporary and local nature. Well, they fixed that with their word magic, and now they have what's called a permanent resident. That's what you're considered, a permanent resident, which doesn't even make sense because the term resident means you're a foreigner there temporarily to do business or something, right? That's it. So now when we reread that MCL that I was just showing you, the Motor Vehicle Code, resident means every person who resides in this state and establishes, which is done by contract or compact, is, look at the Constitution. We, the people, do hereby ordain and establish. Ordain is to make law, right? Establish is to put it into contract, is to put it into action, right? So you have to establish that he or she is legally present in the United States. Well, check this out. This is UCC 9-307, location of debtor, which is very important, okay? You go down to subsection H and it tells you the location of the United States. The United States is located in the District of Columbia, okay? That's why you're a foreigner. That's why you're a resident. And that's why you're always considered to be in interstate commerce at all times. And when you're driving, the reason you're driving, and that is a commercial term, right? Absolutely a commercial. It's one employed to conduct a coach or carriage. And it comes back from the 1800s when there were coaches and carriages. And the person who drove people around in the public coaches and carriages were called drivers. It's called driving. Well, the reason you're a driver is because you're employed by the state. Yeah, that's the state's property, because it's got the state's name right on the license plate, doesn't it? You put the state's commercial advertising. You registered with the state, regnatum, which means to be governed. You give the controlling interest of whatever you register to whomever you're registering it with. So the corporate state's title or name is right on the back of the automobile. So you're employed to drive it. So next time you get a traffic ticket, walk in and say, well, I was traveling. I'm not driving. Oh, you were driving, blah, blah, blah. We don't want to hear that sovereign citizen bullshit, and be like, okay, well, if I was driving, then you must be employing me. Where's my money? Right? So if the state's employing me, then why am I not being paid? It's the state's endorsement on the license, right? You're hired by the state. Give me my money then. What are you talking about? Or are you sure I wasn't just traveling? So, yeah, cattle driver, that's true. How is jurisdiction created? So you have the original jurisdiction, which is common law, and everyone, even kings and the Pope, are subject to that jurisdiction of common law. Then you basically either through contract or presumption enter into a trust arrangement. That's the only way you get into any other jurisdiction. That's it. It's all trust. whether it be a military trust or an admiralty trust or wherever the case may be, right? So check this out. Let's go back to the Buckhat. That's seriously how that's it. That's the only way you can be drawn out of that jurisdiction. So you either accept benefits from some entity or apply to the entity for benefits such as Social Security, which is a deferred retirement benefit, or welfare, Medicaid, all that stuff that automatically by operation of law. So let me show you guys something. This will clear up some confusion for those of you that do not know this. So we're going to revisit this real quick so I can show you. The money will be worth, this is March 9th, House Congressional Record, March 9th, 1933, page 83, second paragraph on the left-hand side. It highlights all the way across, but just look at the left-hand side. Okay, let's see if we can zoom in and just make that a little easier for you guys. So right here, it says the money will be worth 100 cents on the dollar because it is backed by the credit of the nation. It will represent a mortgage on all the homes and other property of all the people in the nation. Now, this is right after they stole everyone's gold with the gold confiscation, the executive order, the Gold Confiscation Act, right? Under threat of penalty, being jailed for 10 years, right? So they did that. They converted the entire currency to debt because prior to that, the currency had been gold and silver certificates, and you could redeem them at a Federal Reserve branch or affiliate, right, for that amount of actual gold and silver. That's what made the paper valuable. Other than that, it wasn't valuable. But because you could redeem it for actual gold and silver, it was valuable, considered valuable. So it was a way to loophole Article 1, Section 10 of the Constitution, right? Yeah, the state is the victim. No, it's not. But somebody actually said that in a case, or the prosecutor said that in somebody's case, or the clerk. It's one of the Jurist Society members like, oh, the state's the victim. The state can't be. Why? What did I do to injure the state? Not conveying the right of my property to it to be used as collateral for a foreign principal? Get the hell out of here, dude. Not a victim. You're victimizing me. You're trying to pillage and pirate me. But anyways, so it was redeemable for gold or silver. Then when they did the Gold Confiscation Act and the Emergency Banking Act, stole all the gold, right, to try to pay as much of the debt as they could. Obviously, that all went to the Rothschilds. There's no gold in Fort Knox. That's asinine. Why do you think Donald Trump never checked? Because he knows there's no gold there. It's not there. And then they converted the system of currency to debt, to fiat, right, which is actually a blasphemy. It's an inversion of let there be light, fiat lux. They call it fiat currency because they're like, oh, yeah, let there be money. Let there be currency. See, we're gods too, right? But anyways, that's how evil these people are. Anyways, they then issued debt currency, but now since they were using negotiable instruments, promissory notes and stuff like that, commercial paper as currency, there needed to be security. Okay. There needed to be an obligor, a source of credit. The government has no credit of its own. It has nothing of its own. It has nothing it doesn't steal from the people. So the people were mortgaged as the credit. They were mortgaged as the surety. And it's not, the system is all about controlling you through this mortgage. And I'm going to show you how they do it. So we go here. You see that they mortgaged you. And I'll back this up even further with, we've got fiduciary foundations of administrative law. So it says the emerging fiduciary model, which a fiduciary is a trustee that can make financial decisions on behalf of the trust. The fiduciary model in administrative law posits that administrative agencies, what are administrative agencies? DMV, EPA, IRS, ATF, all of these are administrative agencies existing. They were only able to be created because of the mortgage of your estate. Now you're under administration. Well, you already were under administration, but now they made it a system, a fiduciary system of administration, bankrolled by a private central bank. That's why they have to appropriate money every year, because the government can't exist beyond 1 year unless it agrees on a proposal to appropriate funds for the benefit of all the estates under administration. That's why everything has to have the illusion of being done for your benefit. But it says these administrative agencies, so we'll just take the DMV, for instance, are endowed with authority to set regulatory policy. What's regulatory policy? Well, it's motor vehicle code. Okay, they're telling you how to use the property because it's not your property. Okay. It's property of an estate that's under administration, and you are merely the trustee of that estate, and you're also part of the chattel property of that estate. You're not considered the owner, and you're very rarely actually considered the beneficiary, but you'd be surprised to know that going to jail is a benefit. So you're like trustee / beneficiary. But, and I know that can confuse some people, trust law is very fast and loose. Let's just put it that way, for a reason, because the birth of the trust were it says the existence of trust owes its or the application of trust owes its existence to the ingenuity of fraud. That's actually in a practical treatise on the law of trust, and it's true. So to set regulatory policy, that's motor vehicle code telling you how to use the property held in trust as collateral. When Congress and the president acting jointly as proxy settlers, proxy means on behalf of, and settler, right? Settler, which I know I did. Oh, nope, I didn't. It's right here. Settlement, the conveyance of an estate for the benefit of some person or person. So when somebody is a pauper, and this is what all the poor laws and settlement laws in England were about, right? Funding their corporate workhouses, which actually the painter talked about in one of his speeches. I was surprised. But anyways, they when a pauper goes and applies for benefits to whomever, by operation of law, they automatically settle their estate with the person providing them the benefits. So that person can make them productive. It's basically the logic of, okay, you can't make yourself productive, so we're going to take you under our guardianship. We're going to make you productive, and then we're going to give you snippets of your productive value in the form of benefits. Okay, that's what happens when you're mortgaged, when you settle your estate, right? So it says that Congress and the president acted jointly as proxy settlers for the sovereign people and entrust them, meaning like the DMV, the EPA, ATF, IRS, all that, with regulatory discretion over an area of public concern. And that's why there's so many committees in Congress, because it's committees to supposedly oversee these administrative agencies who are not actually part of the government, right? They're just exercising quasi-governmental powers through this fiduciary arrangement, this administrative arrangement, and telling you how to use your property, fining and feeing you for the use of it, and fining and feeing you for the misuse of it. Now check this out, mortgage. Remember, you were mortgaged. So it says that the lender, this is from West's Encyclopedia of American Law, 12th edition, and it's under the definition of mortgage. And it says, under early English, and this is not early English in U.S. law, so mortgage is the ancient system of death pledging that Edward Mendel House was talking about in his meeting with Woodrow Wilson, where he said that we will use the ancient system of pledging and force them to register their biological property, etc. Well, it's mortgage. Okay, it's mortgage, and it's ancient. And so this is deceptive when it says under early English and U.S. law. No, mortgage is mortgage is mortgage is mortgage, going all the way back to ancient Persia, ancient Greece, okay, Babylon, I postulate as well. I think that's where the system actually started in Egypt and really flourished in Babylon, right? It's the Osirian myth, but basically being a god of the dead, which is what the judges are with their gavel and their black robes. They're acting as god and judge of the dead, just like Osiris. So anyways, the under early English and U.S. law, the mortgage was treated as a complete transfer of title from borrower to lender. That means the title to your estate. That's what the birth certificate was started to. That's why they started making birth certificates. Guess when they did that? In the 1860s. The same time as creating the federal citizenship, they also started implementing birth registration in all the states. That's why all the states are complicit. Never forget that. They were just as much a part of this as the rest of them, as the federal corporation, the bankers, all of them. They're all a bunch of corrupt, rich pieces of shit. Excuse my language. Anyways, it's not very Christian of me. But here we go. So it was treated as a complete transfer of title from borrower to lender. The lender was entitled not only to payments of interest. This is the most important part. The lender was entitled not only to payments of interest, on the debt, but also the rents and profits of the real estate. This meant, as far as the borrower was concerned, the real estate was of no value, that is dead, until the debt was paid in full. Hence the Norman English name, mort, dead, gage, pledge. And I'm sure a lot of you knew that meant death pledge, but I don't think you realize what that meant for you. You're the property that's been mortgaged, so you're dead to the law. You're dead. That's why they summon you. That's why they say it used to be called a subpoena, but once you're dead, entirely insolvent and dead to the law, there's no need to call it a subpoena. Thank you, God Heart Guardian. So they're entitled to the rents and profits. How do they acquire the rents and profits? Well, that's what the policy enforcers are there for. They're there to enforce your compliance to the administrative regulations, to the trust indenture, right? So they want to see, or they want to pull you over, create an attachment to your estate through whatever account number is linked to it, or attachment to the public trust through whatever account number is linked to it, whether it be your license plate, they can get attached to it, your social security number, or your driver's license number. And once they do that, you remember you are part of the property that is mortgaged. Says it right there in a law review and congressional record. They create an attachment to the estate and create their own obligation, their own negotiable instrument in the form of a traffic ticket or whatever, right? Bonds. They create their own commercial paper, and then they sell those to institutional investors, and it gets even more insidious than that. They get you to do it to yourself. They get you to do it to yourself. They create a constructive trust in your name, and they get one trust, the court trust, the constructive trust, to do business with the U.S. person trust. It's you doing business with you. They hire you, they don't pay you, and then they fire you as soon as they get the security generated and sold. Right? It's pretty insidious. So the Buck Act allowed the states to get in on this action and charge you income tax. And basically what's going on now is all these administrative agencies within the states are actually governing the government because you're considered part of the United States corporation. Okay. And they're making sure you're engaging in activity. And the reason that they're soliciting, as it says in here, is because engaging in commerce with negotiable instrument bills of credit, right, is illegal. It's unlawful by the Constitution. So the Constitution, Article 1, Section 10 says that you must pay your debts with gold and silver, not discharge them with negotiable instruments. So we're all engaged in a commercial enterprise. Well, not me, my claim's on the record, but we're all in a common enterprise of discharging debts, which makes an implied trust called an unincorporated banking association. That's why when they're talking about banking associations in the U.S. Code, they're talking about the 14th Amendment citizens. And that's how they're able to apply a lot of their tax code and everything to the 14th Amendment citizen as part of an unincorporated banking association. And everything that you do within the state is considered to be commercial. So all crimes are commercial. Now, last little bit, and then I want to get into some fluff stuff for a few moments, and then I got to shut this down. But what I mean by fluff is some current events. Challenging. So just let me sum up this. Well, let me show you this first, and then we'll sum it up. But kind of bouncing around a little bit. We got not the veto messages. I know I pulled it up. Where did I put it? This. Okay, so this is Title 18. This is the original Title 18. I'll even show you. And this is quite revealing because they've repealed and omitted a lot of things if you just look it up on the internet. But this is crimes and criminal procedure. And they unwittingly admit, well, they have to anyway, because they always, what people don't realize, they also always have to stay tied to the law. They do. They have to. So they have to somehow extrapolate this as a valid part of a trust existing outside and parallel to the Constitution, but acknowledged as valid by common law. And that's what the unincorporated banking association is all about. Why they converted everything to debt, what the Social Security public trust is all about. Anyways, it says that says to revise, codify, and enact in depositive law Title 18 of the United States Code entitled Crimes and Criminal Procedure. We go down here. This is how they brought admiralty inland. Okay. Special maritime admiralty or special maritime and territorial jurisdiction in the United States. This is how they apply the Buck Act. Well, it's actually the Buck Act is partially how they can apply this, so it's reciprocal. But all right. So obviously, the term special maritime and territorial jurisdiction of the United States as used in this title includes the high seas and any other waters, obviously, right? Within the maritime admiralty or admiralty and maritime jurisdiction of the United States and out of the jurisdiction of any particular state. Now that's important. And any vessel belonging to or belonging in whole or in part to the United States or any citizen thereof. Now, they'll never admit this, but that's how they loosely construe the motor vehicle to be a vessel upon the seas of commerce, but they'll never admit that. So don't ever try to use that as, but it is definitely part of it. It has to be. So, or to any corporation created under the laws of the United States or of any state, right? So it says the high seas, any other waters within admiralty and maritime jurisdiction of the United States and out of the jurisdiction of any particular state. So it's placing you in this counterfeit, this overlay of federal territory, right? And any vessel belonging in whole or in part to the United States or any citizen thereof, or to any corporation created by or under the laws of the United States or any state or territory, district, blah, blah, blah. Now, they loosely construe that to apply to the motor vehicle, but primarily that's about the sea. Now, this is where it gets, it applies to us. It's any lands reserved or acquired for the use of the United States and under exclusive or concurrent jurisdiction thereof, or any place purchased or otherwise acquired by the United States by the consent of the legislature of the state in which the same shall be for the erection of a fort, magazine, arsenal, dockyard, or other needful building, right? And now this one's actually pretty interesting. Any island, rock, or key containing deposits of guano, which may, at the discretion of the president. I don't know what that's about. I just thought that was interesting. So this is only part of it, though. This doesn't automatically do the whole thing, right? So this, in combination with, actually, I might already have it pulled up. It should be Article 4. Yep. Right here. The Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. Well, that's you if you're a 14th Amendment citizen. So now they're able to take the 14th Amendment citizen, essentially the federal territory. And so this overlay, the entirety of it and all of it, the motor vehicle code, everything, all the licensing, registration, all this stuff, only applies to 14th Amendment citizens because they are the only ones Congress could ever mortgage. And so challenging the validity of the 14th Amendment is the best and most effective way to combat these pirates. You have to challenge it right at arraignment and say, yeah, all this only applies. Well, actually, you always want to ask questions. Say, what are the nature and the cause of the charges against me? I need to see a verified complaint. You know, you were speeding or whatever the case may be, right? And so what makes you think that these administrative regulations apply to me or my property? Right? I'm not engaging in commerce. I'm not a 14th Amendment citizen. You presume that I am, correct? You know, that sort of stuff. Nature and cause of the charges against me, right? And standing on the fact that you are not engaging in interstate or international commerce, because you're not, are the best defenses, and then challenging the validity of the 14th Amendment. Writing it. So before you even ever get into court, what you need to do is you need to file a notice of special appearance with the court. Once you get, you know who the judge is and everything, or magistrate, file a notice of special appearance, serve it upon them, or send it certified mail, and have it accompanied by a legal brief delineating everything I've taught you today. Okay, the 14th Amendment is voluntary, right? It's a fraudulent contract. It's an unconscionable contract because as one of the people of the state of Michigan, I have unalienable rights, including the right to travel, the right to engage in trade, right? The right to just freedom of locomotion, all the common law rights that any other free sovereign would have. And why would I exchange that for privileges and immunities and sacrifice my sovereignty to be brought under administration? and have all my property held in trust as collateral for the debt of a foreign principal. It's slavery. You can't require me to do that. And you have these documents that I've shown you, like House Congressional Record, June 13th, 1967, that shows you. Even Congress knew, and it's articulated in Coleman v. Miller from 1939, that the governments of the states that rejected this amendment were unlawfully replaced by the federal Congress, and therefore those states were deprived of their equal suffrage according to Article 5. And that is the very reason why the court has never upheld the validity of the 14th Amendment. So first of all, you're presuming I'm a 14th Amendment citizen, and the 14th Amendment has never even been confirmed as a valid amendment because of the way that it was ratified. Secondly, even if it was valid and somehow you guys deceitfully went through and said, oh no, it's cool to just replace entire governments and ratify the fundamental document of the Republic, right? Even if you did do that, it's voluntary. And you always should have this case, the McDonald v. State, right? One may be a citizen of a state and yet not a citizen of the United States. It's right there. Enshrined in case law. Stare decisis. It's already been decided. Okay? Now, you trying to force me into this citizenship is actually piracy, and it's attempted slaving. You're trying to enslave me. There's no really other way to look at it. What else would you call trying to take all of someone's property and place it in a trust to be used as collateral for the debt of a foreign principal? And then on top of that, because of what you just did, this person's now subject to frequent pillaging by uniformed thugs. Driving is a privilege, but driving is commercial. Okay? It is a privilege. Driving is, right? Because all commercial activity is considered a taxable privilege of the state. What they don't tell you is that driving is commercial. One has to be employed to be a driver. So what they secretly do is they have the state employ you by issuing you a license. But then they don't pay you. In fact, quite the opposite. They control you. And they can only do that through the 14th Amendment because guess what? The state could never tell one of its people what to do with their property unless they came under administration of their own by their own action, which would be done by being a drunkard, incompetent, spendthrift, being underage. So final thing to just put the cap on this whole United States citizenship thing here, right? We've got infant. Hold on. It's right here. No, I have it. It's United States citizen as an infant. Okay, so it's Title I, Section 8, the U.S. Code, right in the very beginning for a good reason. It says, in determining the meaning of any act of Congress, okay, or of any ruling, regulation, or interpretation of the various administrative bureaus, such as the DMV, right, EPA, IRS, etc., and agencies of the United States, right, such as, well, I just listed several of them. The words person, human being, child, and individual shall include. Now, you guys have heard the term including but not limited to. There's a reason that's a thing, and you know it, is because the word include means contain, like it means only this. To include something is the opposite of excluding it, meaning putting it without. To include is to put it in, right? And so when you say include, but you don't add but not limited to, so you don't say including but not limited to, you just say includes, right? That means only this, okay? So if I say car, in determining the meaning of any act that I write with my pompous narcissistic legislation, right? Because I can just make law all of a sudden, like I'm God. The words car or an automobile mean Volvos and Lexuses, okay? Or it includes Volvos and Lexuses. So the word car or automobile includes Volvos and Lexuses. What that literally means in statutory construction terms, it means anytime you see the word car or automobile, I'm only talking about Volvos and Lexuses. That's it. So now watch this. The words person, human being, child, and individual shall include every infant member of the species Homo sapiens who is born alive at any stage of development. So every infant member of the species Homo sapiens, right, which is not, they say is man, but they're using the term Homo sapiens for a reason. Homo sapiens who is born alive at any stage of development. That means if you're a person and you're 50, you're an infant. If you're an individual and you're 75, you're an infant. And the reason being is because the minor account attached to your primary Social Security trust account, the minor account, if you've never accessed it, you're considered a minor. And you don't want to access it. You don't want any of the benefits. You want to get rid of the 14th Amendment citizenship altogether. Altogether. So you're an infant, though, and you're literally under the guardianship of the U.S. corporation under the doctrine of parens patria, or government as parent, as a 14th Amendment citizen. So, all right, that's pretty much what I wanted to cover here. Now let's take a look at where this is going and why it's so important before I get off here. Let me close this window with a million tabs on it. It's a lot of information I have to reference, a lot of stuff to prove it to you. So I have a lot of tabs open. I appreciate you guys being patient while I sift through them. Oh, here's a little something just on the side real quick. Check this out. How I told you, because you're an infant and they appropriate money against your estate because you're a trustee of your own estate, which, so take, like, for instance, if your parents both, if your mother and father both passed away and they had a substantial estate, or any estate, doesn't matter, because estate is just essentially your personality, labor, and property. That's what it is. And you would be property of your mother and father until you become of age. So that's part of their estate. You are part of their estate, right? And it doesn't matter if they're rich, poor, everyone has an estate, because the estate is just your interest in property or ability to acquire it. And that's all determined by your free will and personality. So with that being said, imagine that your mother and father pass away, unfortunately, and you're not of age. If there's no other family member to take guardianship and executorship of that estate until you come of age, then you come under administration. And you are literally an infant ward of the court. Right? Well, now they figured out a way to extend that to even people over the age of 21. And that's through the minor account thing and all that. That's definitely a conversation for another time, though, because that gets more into the UCC stuff. And I'm very knowledgeable in it, but I despise, I don't think anybody should play in their sandbox. I think we should just kill the 14th Amendment. Okay. So you are considered essentially a ward, right? Well, it's like that the entire time, and everything that the court does, the administrator, right, in this scenario I just laid out, has to be for your benefit. Whatever he tells you to do or whatever he does with the property of your estate has to be for your benefit. And that's in the Magna Carta. They all derive their jurisdictional authority from the Magna Carta. Actually, I don't know why I didn't show you that real quick. Let me show you that. And then I'll go over to the other stuff. All right, so they all derive authority from the Magna Carta. Oops. And this is why. So like 1 through 5 pretty much dictate, they lay out the whole groundwork for administration, okay? Says like basically if the heir of such persons under age in a ward, I bet you didn't know that's what the Magna Carta was about. You'd think, you know, they call it the Charter of Liberty primarily because the priest class kept taking the property of the barons under administration and stealing it. So that's why this was written. But anyways, but if the heir of such person is underage in a ward, then he comes of age, he shall have his inheritance, right? The guardian of the land of an heir who is underage shall take from it only reasonable revenues. So this is why it's called an office of profit. And this is why they want everybody in administration, because they get to take revenues from it and control your property. Revenues, customary dues, and field services. He shall do this without destruction or damage to men or property, right? For so long as the guardian has guardianship of such land, he shall maintain the houses, parks, fish, reserves, ponds, everything else pertaining to it from the revenues of the land itself. So they extrapolated that to when there is no revenue, say like when the United States went, you know, the Banking Relief Act and they mortgaged the estates, they used the logic of, well, there is no money. We're in an emergency situation. So we have not only the right, but the duty to mortgage the estates of those under our guardianship. meaning the United States infants, the 14th Amendment infants. And so that's why they did it. And I'll prove it because right here, Michigan, so they used to be called the revised statutes of the state of Michigan. But then when they started burying common law and mixing all the other jurisdictions like civil, admiralty, abolishing the distinction between common law and equity, they ended up calling it the revised code or the Michigan compiled laws, right? So I do have this somewhere. Don't tell me I put it over here. Okay, maybe it's not on this page. Maybe it's on. All right, let's see if I can look it up real quick. Because that's kind of annoying. I thought I already had it up. Revised statute, state of Michigan. Okay, so we'll do Michigan. Whoops, that's an N. Compiled laws right there. Okay, check this out. The very source of their jurisdictional authority for that reason is the Magna Carta. And this might take a few moments to open, but when I show you this, let's close that. Preliminary chapters. Look at this. Before the Declaration of Independence even is the Magna Carta. That's why I call the Magna Carta a double-edged sword. They have the Magna Carta listed first because by this time in 1929, they had taken almost all of the state under administration in preparation for what was going to happen in 1933. They had already planned this in advance, right? But my point is the Magna Carta, they have to follow it as far as the administration is concerned, which is why when you're a free man, you reclaim your estate as one of the people, you can hold your own court. Because no free man shall be deprived of his court is also in the Magna Carta. But when you're under administration, you have to do what the administrators tell you. So it's freedom for people not under administration, the Magna Carta, and it allows administration for the controllers if you don't know how to overcome that. So that's why it's the very source of jurisdictional authority. All right. And with that said, we're going to hop over. I'm going to show you guys something interesting just for your own knowledge. And that is this. So Title 42 of the U.S. Code, you guys know the space program. You're thinking, okay, well, if they have to do everything for your benefit, then how did they start the space program? Well, first of all, what they did, and the benefit is just lip service. They're really evil, satanic, and everything they do is actually harmful to you under the guise of being philanthropic and beneficial. Just look at all these NGOs, Bill and Melinda Gates Foundation. That's why they have all these NGOs, by the way. All right, so it's actually under public health and welfare. What? The space program's under public health and welfare? Why? Because it has to be. Because they have to act like it's for your benefit in order to appropriate money to fund it. So this was really a trick to be able to appropriate money to fund their black budget operations through NASA and the intelligence agencies. And look at how sick this is. Every sentence or every paragraph starts with the Congress, the Congress declares that the general welfare and security of the United States require. Okay, go down to the next sentence. The Congress declares that the general welfare of the United States requires. Notice how they keep saying general welfare. The Congress declares that the general welfare, same thing. Congress declares that the general welfare of the United States requires, and they have to use that terminology in order to justify the appropriation because you are in a public charitable trust. And that is why these politicians head up so many NGOs and nonprofits. That's why that's how they funnel this public funds out of the public coffers into private pockets and back into their own pockets. And they just wash it through you and incur more debt to just further solidify your slavery. You're probably pretty pissed right now, I would imagine, and I can understand. So, all right, last thing I want to tell you guys, and then I got to get out of here. I got to go drive 45 minutes away, but I think that they're going to start kicking off making this permanent this year. So you guys really need to go through, look at everything I've shown you, internalize it, comprehend it, distill it into a fine nectar that you can use to defeat the pirates in court. Because if you do not, and they get this digital system set up, and trust me, they know that you're not going to accept it. They know that most people in this country are not going to accept it because AI is watching this stuff all the time, all the data on the social media, I tell you all the time. And that's how they make their decisions of how to implement various policies based on the projected resistance that AI calculates based on the data. that it has access to, which is just unimaginable, the amount, right, that we voluntarily give them, even right now, me talking on this stream, right? So they know you're not going to accept it. They're going to implement some sort of catastrophe. And I already know, I'm fairly confident, and I hope I'm wrong, so don't think I'm like being a doomsayer, but I'm pretty sure they're going to crash the economy this year. So what they've done now, like I said at the beginning of the stream, gold and silver were artificially deflated. And that was to keep the international debt down for the United States, because if the gold price kept, so the gold clause, HJR 192, states that the Treasury has to pay all debts in gold, right? Well, if they didn't artificially suppress the price of gold to a certain degree while they inflated the currency just beyond beyond comprehension, then pretty soon the rest of the world, before they were able to compromise everybody through, Maxwell and Epstein's blackmail operation, that's what that was all about, to get all the world leaders on board. That's why it's connected to the tech companies so intimately, with like Peter Thiel and that Alex Karp guy. Peter Thiel was buddies with Epstein, went down to that Zorro Ranch and all that stuff, right? So you got to look at the internet interconnectivity. Whitney Webb actually does a very good job of connecting all the dots. But the reason that they're all connected is because they were blackmailing everyone to get them to adopt this digital prison system. And it's all to make permanent this very trust indenture I've spent the last 2 hours explaining to you. That is actually the end game. All conspiracies lead back to this, the enslavement of you through subversion of the law by establishing a counterfeit administrative system over God's original system, right? So, I mean, it's funny. They even put it's in the language. There's a very intimate relationship between AI and law in general, because when you look at how societies are developed, right, statutes are codified like codes, right, to program different systems into society. It's the same thing. It's just two different spheres, essentially, right? One's computers, the other's society. So, and now they're trying to merge the two. And they're trying to make the world trust permanent. So they know you're not willingly going to accept this. And they knew that world leaders wouldn't do it without blackmail. So that's what that was all about. So they're going to cause some sort of cataclysm. That cataclysm, I think first, I don't know what's going to come first. I don't know if it's going to be pulling the rug out of the economy. But like I said, they artificially deflated the prices of gold so that the other countries didn't catch on to the fact that, this debt system was being built and demand their treasury bonds be redeemed before they're worthless, or demand the money they lent back, right, or whatever. And so the other reason that they've kept it artificially deflated is because a dollar, which is the measurement of U.S. currency, is actually an ounce of silver. So silver has been heavily suppressed, the price of it, right, to keep the illusion up that the Federal Reserve note is actually $1 and has value. It's like, and most people think that it's $1. It's not. It's mistakenly called $1. It represents a debt that is to be paid in dollars worth of gold, right? The equivalence between the ounces of silver and the ounces of gold. Anyways, I'm not going to get into that too much because I'm probably confusing people, but now they're removing that artificial deflation, and it's causing the cryptocurrency prices to plummet, like crypto crash, right? I think Bitcoin just lost like $20,000 the other day. XRP is down. They're all down for the most part. And the reason that's going on is because Trump and his team are in the background buying up all the crypto that they want to use, the XRP and Bitcoin, stuff like that, to create their sovereign wealth reserve and get ready to switch over to the new financial system. And then once they're done doing that and buying all that, they're going to let the bottom drop out of the economy. That's what this government shutdown is all about. They're not really disagreeing. They're all on the same team. This is an orchestrated act. And they're letting all the systems of government that people had depended on, like welfare and stuff like that, slowly just collapse. And then what you're going to have is chaos. And I do believe they are going to try to implement the fake alien thing. There's been a lot of buzz about that. So check out what this lady has to say real quick. And she just, here.
Okay, I can. Okay, so it's on the CNN news. So the month of November, they told all the southern states to hold back Section 8 and their EBT benefits. Okay, so that means
I actually like her take on it. I agree with her. Obviously, you guys would know I do once you hear what she says.
that no Thanksgiving and no Christmas. Okay, so therefore, you know what? Whoop de doo. Okay, whoop de doo. Because let me tell you something, American people. It was only supposed to have been a temporary thing. Okay, I'm hearing people all
actually was never even supposed to be a thing. That's communism, and it could not be a thing without setting up this massive national trust system via the 14th Amendment and the mortgage of your estates. But the point is, we don't have to listen to that whole thing. And she's right. They're ending that. And she goes on to say, a lot of people have iPhones and they're bitching about their food stamps and Section 8 they've been in for 20 years and they don't move. Yeah, she's right. If you're going to implement, that should all be private and charitable anyways, never forced at gunpoint. You can't take from me to give to someone else. Founding fathers are rolling over in their graves, right? Well, the good ones, the ones who weren't a part of this plan the whole time, which is probably very few of them. I'd say Patrick Henry for sure. Thomas Paine, maybe. Jefferson, I used to think so. I don't so much think so anymore. Anyways, not supposed to have that system. But the fact that the system is at this point and they're cutting off that funding, that's going to cause a lot of discontent, we'll say, right? To say the least. I mean, we're talking, you think no King's protests are bad, which I think that's retarded anyway, just in my opinion. It's like you want to protest the 14th Amendment because Donald Trump could do whatever he wants. He's a good businessman, but he wouldn't be able to affect you at all. And none of the stuff that his digital tech overlords that are running the show or whatever would be implemented. Right? So it's the 14th Amendment you have to fight. Now, the other thing that's coming up that they're alluding at is this stupid thing right here. And they started the PSYOP with the information during the summer, like June, July. They're like, in November, we're going to have a hostile alien attack. And then it died down. So they injected it into the public zeitgeist, got the predictive programming out there. And now they're taking these same old interviews and look at this post is from 4 hours ago. They're recycling it and bringing it back to the public forefront because I think what they're going to do is they're going to drop the ass out of the economy, excuse my language, and try to do Project Bluebeam at the same time. You got to think this is the success of the New World Order hinges on the United States adopting digital currency and digital ID. The entire success of it, they can force all the other countries to do it. And they're doing a good job of protesting it, but they gave up their guns. So, right. They're legitimately afraid of us. The elite are. They're legitimately afraid of us and they do not like how we've been waking up. So I think they're going to pull out all the stops. They're going to hit us with some Bluebeam and Great Depression 2.0 simultaneously. Now, I hope that I'm wrong, and I'm not trying to fear porn, do any of that stuff. I just want to call it. I'm calling it. I think that's what they're doing. I hope I'm wrong. I hope that, I can be on stream January and you guys can type in the chat or come up on Pam and be like, dude, you were wrong. And be like, thank God I was wrong. So glad I was wrong. I would never have wanted to be wrong more in my life, but I see all the signs. The writing's on the wall. The writing is on the wall with this, especially with the economy. And this, they've been planning to do this for so long. So let's take a look at what they have to say about it, right? So the Project Bluebeam bullshit.
The world listens, but this time, his words feel more like a science fiction thriller than breaking news. The billionaire innovator has just confirmed what many have only dared to speculate. The mysterious object, known as 3I Atlas, isn't just another rock drifting through space.
Just so you guys know, I know space is fake. I mean, it's the heavens, right? Just like it says in the Bible. I know that we are not on a spinning ball whirling in 4 different directions simultaneously through a vast expanse of nothing. So I just want to put that out there. That's another reason why we can just be absolutely sure this is bullshit, right? But apparently he captured a picture of it. Okay, this is just an AI clipped together video. And this is how they're going to try to sell it. So people who know that that's all bullshit, right? Excuse my language again. Yeah, I need to stop that. But people who know that's garbage and a bunch of fallacies and lies also know that, well, generally it's accepted that there are entities here that they've been in communication with. I mean, Jack Parsons, Aleister Crowley, John Dee, all the way up to today. Like, people are, talking about these. There's the one guy who's basically a medium and says he's possessed by 4 different demons at the same time. He says this. I forget his name off the top of my head, but I showed him a couple streams ago. And he's one of the people with the most influence in the tech world. That doesn't even make sense, unless that's where all this technology is coming from. Now, I'm speculating. I can't obviously prove that like I can the stuff with the law, but I think they're going to try to spin it into like, oh, we're contacting aliens. So that one of the head researchers at CERN had come out, I think it was like 10 years ago or something, and said, yeah, what we're trying to do, basically the existence is like a book, okay? And each page is a dimension. And what we're trying to do with CERN is we're trying to tear a hole in the page to another dimension, so we can either send something through or something can come through to our side. Okay, so they're using this thing to try to contact, and it's built right over where the Bible said the bottomless pit where Apollyon is. And in fact, at one point in time, you don't have to believe me, but I promise you this is true. I looked up keys to the bottomless pit some years ago on Google because I seen somebody do it on a reel or something, or whatever they called them back then. I looked up keys to the bottomless pit, and it took me to CERN Recruitment Center. I shit you not, it did. It really did. And you don't have to believe me, but it did. I doubt it does that anymore, but it absolutely did. I even showed people. I was like, look, check this out. Put in keys to the bottomless pit. Boom. CERN Recruitment Center. So this guy is going to try to say that at CERN, they're using the collider to open the portal. And listen to what he just says. We're only going to play it for a couple seconds, and I got to get out of here. But
CERN, they've used their collider to open up a portal to communicate with extraterrestrial beings.
Whoa.
And one of them are the occupants from 3i Atlas.
To be clear, CERN already has a room and a technology to open a portal to talk to extraterrestrials.
Yes.
But recently, they also used it to communicate with the beings on 3i Atlas.
That's correct.
Okay, go on.
So that's how they're going to try to spin and sell it. You know what I mean? So I'll, let's see if I can link let me get out of here and do this. And I'll share it and I'll put it in the chat because I do have to shut this down. Whoops. But that way you guys can watch this BS. And yeah, we all know what that's going to be, but they're going to try to spin it like, oh, we were talking to these things through CERN and we drew their attention and they came here and now they're going to take us over and we must unite humanity under the one world government and all that good stuff, just like Ronald Reagan said in his speech. So at the end of all this, it is of the utmost importance that you recognize the linchpin to their entire scheme. That not just this, what we've been dealing with the administrative agencies such as motor vehicle code and revenue code, tax codes, all that stuff. They're all revenue codes anyway, as a result of the 14th Amendment. But the entire success of their New World Order agenda to implement a technocratic communist police state across the world under a one world trust, ultimately under the Pope and the Crown Corporation, hinges on the 14th Amendment. And I hope today I have successfully proven, and shown you how to prove the voluntary nature and the invalidity of that goddamned amendment. And it is a goddamned amendment. And it is the entire source of all of our problems. You could keep the Federal Reserve, you could keep the central banking system, you could keep all the bar associations, right? You take out the 14th Amendment Jenga piece, and the entire tower collapses on its own. There's nothing, it has nothing to feed off of anymore. You starve it. It's a vampiric system and you starve it. Right? So with that, thank you guys for joining me today. I plan on doing this regularly. I'm going to get down a schedule Monday, Wednesday, and Friday now that I've got the International Truth Expo coming up November 7th, 8th, and 9th. I'll be in Quartzsite, Arizona. And I've been preparing for that, but I've pretty much got things settled down. So I should be back probably Thursday morning, and I look forward to seeing you all then. So have an excellent afternoon, and I'll see you later.